thing.
No, please.
Yes, please.
Lordship, item number 39. I'm just praying for some accommodation for today. I'm intending to file one additional affidavit with regard to some subsequent development laws. It will be taken up any day in the next week, Lordship.
As prayed for by Mrs. S.P. Chaudhary, learned counsel appearing for the appellant, relist after 2 weeks on a date to be fixed by the registry.
Just in the matter next week, Lordship. Next Friday, Lordship.
After a week. Yes.
Next Friday, Lordship.
Next.
Please, Your Lordship, I beg to mention item 4 of today's daily list for an adjournment, my lord. Senior advocate Mr. K.P. Pathak is leading the matter, however, is unwell.
As prayed for by Ms. S. Sharma Hajorika, learned counsel appearing for the petitioner on the ground that the leading counsel, Mr. K.P. Pathak, learned senior counsel, is indisposed, relist after
3 weeks, my lord.
3 weeks on a date to be fixed by the registry.
Obey. May I please, Your Lordship, I beg to mention.
Mr. Deori, you were there in that matter.
May I please, Your Lordship, I beg to mention 2 writ petition for listing Lordship on Friday.
Oh dear. Yes, next.
May I please, Your Lordship, with the consent of other side, I beg to mention item 7. Senior advocate R.C. Soikia is out of station, so item may be listed after 2 weeks.
On item 7, your name?
J.P. Borua.
Have you informed the other side?
Yes, Lordship.
Mr.
J.P. Borua.
J.P. Barwal, learned counsel appearing for the petitioner, seeks posting of this matter on any other date in view of the fact that the leading counsel, Mr. R.C. Saikia, is
Out of station.
out of station. Prayer is not opposed. Relist after
2 weeks.
2 weeks on a date to be fixed by the registry.
Oblige, Your Lordship.
Lordship, with regard to item number 8, Your Lordship,
Yeah.
by the Honorable Court's order last dated, Your Lordship, we were to file our affidavit, Your Lordship. We have of respondent number 4.
Have you informed the others?
Yes, with the consent of the.
Any objection, Mr.
Actually,
Hussain, right?
Madam, that chance was given several occasions.
So are you objecting
No,
today?
No, madam.
As prayed for by Mr. B. Deori, Leonard Standing Counsel?
I'm for respondent number 4.
Leonard Counsel appearing for the respondent number 4, which is not opposed by, which is not objected by the other side. Relist on such and such data. That data. When do you want it, Mr. Hussain? Yes, please sort out a date and give it to the court master. Next.
May Lordship, should like to mention item number 17, Lordship.
Yes, it's a transfer matter.
Yes, Lordship, actually, there's been some new development, we'll be filing an additional affidavit. So,
You're for the petitioner.
Yes, Lordship, 1 week time may be allowed.
Your name?
N.J. Chaudhary.
As prayed for by Mr. N.J. Chaudhary, learned counsel appearing for the petitioner on the ground that during the pendency of the present writ petition, there has been certain development in the matter and the same is required to be brought on record, relist after 2 weeks,
1 week, Lordship.
after 1 week on a date to be fixed by the registry.
Oblige, Lordship.
Next. Yes, Mr. Batra, you want to make a mention?
No, no. Just waiting for the item number 1. Lord, my junior colleague would like to make some submission.
Yes, yes. We are promoting her. That's a very good thing. Yes, it's a MAC appeal.
Yes, sir.
Yes, give me the file.
Item number 1.
My court master seems to be not giving me the brief because of junior counsel appearing, huh? Why are you not giving me the file? Yes.
May it please your lordship, this matter is wrongly listed in the admission column as it was admitted long back on 7th October 2020. I have checked the records and as per office note dated 17/6/2025, LCR has been received and all the respondents, that is respondent number 1, 2, 3, 4 and 5 have filed the wakalatnama.
So service is complete.
Yes, yes, your lordship, service is complete.
Service is complete. And the case records have been arrived.
Yes.
So we can fix it for hearing.
Yes, your
After 2 weeks, Lord.
Your name?
B. Paul.
Ms. Paul, refrain
On
from
behalf of
Ms. Paul, refrain from using the term lower court record LCR. All right.
Yes, sir.
Henceforth, try and adapt the word trial court record.
Yes, sir.
Uh, heard MS so-and-so Paul, learned counsel appearing for the appellant. Also heard Mr.
M. Talukdar,
M. Talukdar, learned counsel appearing for the respondents.
1, 2, 3.
1, 2, 3. No one is appearing for 4. No one is
4
appearing
and
for
4.
4. None appears for 4 and
Last,
5, despite
Council's name has been reflected in the.
despite the names of the learned counsels appearing for the aforesaid respondents being reflected in the cause list. Service as such stands complete. It further appears that the case records has been received. Post for hearing when?
After 2 weeks. Lordship.
After 2 weeks on a date to be fixed by the registrar.
Lordship, this petition relates to TRS benefit of the petitioner, Lordship.
Yes.
My lord, is Assam Plantation Crop Development.
No, last time a communication was placed before this court, as per which the case of the, I think, petition benefit for the petitioner was supposed to be placed before the next budget. What happened? Where is the up-to-date information?
Then Council of Finance,
Huh?
just instructed to finance.
Oh, where is finance after some time then? Mr. Counsel, try and get hold of someone from the finance because I think the up-to-dates, we need to know what is happening.
I don't know, one thing is there.
Yes, next.
The finance coming. Finance.
Let item 3 be first taken and then
Regarding pension act of the GNC employee, my lord, they have involving 580 for annual calculation is going on. What will post it after 3 weeks, my lord. In the meantime, maybe.
this is pending from 23.
Yes, my lord, because involving 583%.
Maybe, maybe, but 2 years seems to have been elapsed from filing of the writ petition pertaining to pension.
This is only one.
Mr. Bora, I shall give you the time, but ensure that on the next date fixed, the requisite instructions and or affidavit is placed on record,
sir.
failing which the erring respondent shall have to be in court to explain.
What will after posted after 3 weeks, my lord. In the meantime.
I'll give you the 3 weeks
Lord.
that you are asking for,
Lord, sir.
but with that subject to.
Lord, sir.
Heard Mr. Y.S. Manan, learned counsel appearing for the petitioner. Also heard Mr. S. Bora, learned standing counsel for the GMC. You are BORAH or BOR? A, correct. Because here on the last occasion by inadvertently an H has been added. Bora, huh? It appears that on the last occasion, I-24/9/2025, upon the submission made by the learned standing counsel GMC to the effect that appropriate steps has been taken by the authorities for the release of the pensionary benefits. However, the up-to-date instruction as regards whether, however, the up-to-date instructions were being not available on that date, the matter was posted today. Mr. Bora so-and-so seeks further 3 weeks time to place the updated instructions from the department. Considering that this matter is pending since 2023, a last opportunity is given to the respondent corporation to place the up-to-date instructions, failing which the matter shall proceed in accordance with law. It is needless to be clarified that in the event no affidavit has not yet been filed, no affidavit in opposition is filed and or the instruction as called for is received, is available before this court on the next date of listing, the erring respondent shall also additionally be present in the court, either in the physical or in the virtual mode. Yes, next.
Lordship has fixed a date.
Date of the deed of
3 weeks. Sir.
17
stand
Obliged.
corrected.
Obliged.
Yes.
Number 5 and 6.
May I please the lordship?
Salary sanction,
No, salary not sanctioned, lordship,
not sanctioned.
not sanctioned.
That's what, that
That-
is the subject, right?
There's the subject, they came with the impugn order, I have challenged, lordship.
Ms. Mushahari,
Lordship, instructions, I have just now received it, your
you've
lordship.
received the instructions.
yes,
You
your
place it by way of an affidavit
Yes,
then?
your lordship.
Yes,
MSD Mushahari, Leonard Standing Council, Secondary Education Department submits that she has received instructions in the matter today and accordingly seeks a short accommodation to place the same by way of an affidavit. Prayer is allowed, relist after
2 weeks, your lordship.
2 weeks on a date to be fixed by the registry.
I am paying for fixing a date, lordship, because.
It will come,
since
Mr. Counsel.
2008,
All right,
lordship,
next.
Obliged.
Not getting salary.
Next.
Obliged.
Retirement benefit, why are you not giving Mr. Cholia?
Lordship, here on the last date, a statement was made by the PNRD that they have sent a proposal, Lordship. We have written to the department and the department had no record of the same.
Yes,
And-
PNRD.
PNRD, Lordship,
Where is PNRD?
Lordship, I have the latest that we are still awaiting the.
Yes, PNRD. Is there shortage of penal advocates nowadays in the departments? That the court has to keep waiting for the concerned penal advocate to appear before the court? Because as far as I know, there are quite a
Yes, Lordship.
few in the departments concerned.
Lordship may pass over the matter, but I'll just inform.
I shall do that, but in every matter is either someone from this or the other department is not here. It causes difficulties to the counsels for the petitioners. They are waiting. They have also other matters. It's not that the panel advocates are only busy. Yes, next, time being. You wait, ma'am.
Item 10.
Yes, Mr. Chetri.
Lordship, in earlier occasions, after hearing at length, Lordship passed the order.
This court passed the order.
Yes.
Where?
Lordship,
17-9.
yes.
PHE. Your PHE.
Yes.
Where is PHE? PHE is again absent. What is this going on?
In such case, my lord, earlier
No,
occasion of.
because it seems PHE has submitted, they have received specific instructions.
Yes. on
Where are those instructions? No, what is this going on? Why the department councils are not in the court? Mr. Bora, please inform the Advocate General.
Yes.
Please inform. Matters cannot be just kept for time being one after the other because of no appearance on the basis of the, Mr. Chetri has been here since 10:30.
Yes.
So was the other councils appearing in the other cases. They also have other matters to attend. Yes, next. You wait for some time or you want another date, Mr. Chetri?
For the timing, I will wait.
You wait because let's see what development has happened.
Item 11.
Yes, petitioner is in person here. Your name, please? Mr. Roy. Yes, Mr. Roy, what is this case and who is appearing for the other side? Where is PNB? Now PNB is absent. I'm sorry, Mr. Roy, but you are noticing what is happening. What to do now? Where is PNB? Where is the respondent? Authorities, council. This is not fair. This person is present in person and the counsels for the respondents are not here.
Few minutes back, lordship, the assistant of the senior counsel was.
All right, I'll have it. I'll keep it for the time being. You please have a seat. Whenever you see that the assistant counsel is coming, please ask him or her to inform the court master. Your matter will be taken on priority.
What?
Yes, next.
Item 12.
So in this case, I placed some time also, because this.
See the last order.
Yes, what is this?
This is regarding your lordship MSCP scheme, whereunder the state government regular employees who have been working for 10, 20 and 30 years and haven't been given the promotion, they shall be granted their benefits. So in view of that, the other similarly situated employees, your lordship, they have been granted same benefits and accordingly they have been getting their salaries more than that of this repetition. And in the meantime,
Who's appearing for the board
Also, I am appealing for the board, also I placed for some time also.
to file affidavit?
Also, what happened, the CEO is transferred also, and new CEO.
No, earlier it seems some affidavits have been filed, but
Yes,
you have not filed, your department.
I have filed also.
Then an additional affidavit is required in terms of 24/9/25 order.
yes.
No,
Your
the
lordship, can you see that order?
Yes, but let them file it because this is a detailed order. Let the affidavit come. How much time you want?
He was takes time also.
Huh?
Takes time.
Why?
Yes, your lordship.
Also new, the CEO is already transferred.
All right, I'll give you 2 weeks.
2 weeks.
A new incumbent has come, right?
Yes.
So then,
To join.
you see, affidavit has to be prepared by you.
But instruction is withheld from the.
So instructions, you call for it. We are giving you 2 weeks time.
Already send my letter also.
Because the otherwise main affidavits have already been filed. Heard Mr. P. Sharma, learned counsel appearing for the petitioner, also heard Mr.
MJ Gogoi.
M.J. Gogoi.
MJ Gogoi.
Sorry,
MJ Gogoi.
N. N.J. Gogoi, learned
For respondent 3 and 4.
learned counsel, turning counsel for the respondent numbers 3 and 4, and MS Arbora for
Respondent number 1.
respondent number 1. Mr. So-and-so Gogoi seeks further 2 weeks time to file the affidavit in terms of the earlier order passed by this court. Prayer is not opposed, relist on such and such date, on such and such date.
Date may be fixed.
I'm giving it.
Please.
Can I see the number?
Yes, please call the other matter, item number 11. Mr. Datta, you are appearing in item 11 for the respondents.
I'm sorry, I'm a bit late.
No, that's all right. None of your juniors were also here. Apparently, there's a petitioner in person. That is why. Yes. And it so happened, Mr. Datta, that for some reason in all the prior matters, either the panel advocates of either one or the other department is missing. So practically all the matters were being kept for time being. Anyway, they are all with councils, but this is one matter where the petitioner was in person. That's why I made an exception to take it immediately. Yes. What is this matter? The affidavits and have already been filed. Pleadings are complete. Mr. Roy, what is your grievance?
Grievance lordship, actually, I'm a retired banker. In 2012, I was disqualified on the basis of an uncommunicated APR from promotion process.
Uncommunicated
APR, ACR, what is called ACR also, in bank it is called APR.
appraisal report.
Annual appraisal, performance appraisal. So I challenged that decision of the management. So this honorable court passed an order in 2014. Lordship will find that order in page number 30, it starts from 30. The operating part is in page 45.
Page
45.
45.
Yeah.
Yes, please.
That's 25. Can I read, Lordship?
Yes, please.
So that being the position and having regard to the law laid down by the Apex Court, the following directions are hereby issued. Number 1, entries in the APR of the petitioner for both the years 2010-11 and 11-12 be communicated to the petitioner within a period of 30 days from the date of receipt of a certified copy of this order. 2, petitioner may submit representation before the bank against such entries within 30 days from the date of receipt of communication of the entries in the 2 APRs by him. 3, such representation, Lordship, this is very important. Kindly take note.
Yes.
Such representation of the petitioner shall be considered by an authority of the bank who is placed higher in office than the accepting authority. Consideration of the representation shall be done fairly and objectively with an open mind by the higher authority within a period of 2 months from the date of receipt of the representation. Decision taken on the representation shall be communicated to the petitioner. Number 4, once the above exercise is completed within the period specified, and if the petitioner attains eligibility, bank shall hold a review DPC to consider the case of the petitioner for promotion to senior management grade scale 5, along with the batch of respondents number 5 to 49 within 2 months of completion of the exercise covered by direction 1 to 3. So after
So
this
this representation was directed to be considered
By an authority?
along with the other similarly situated,
No, Lordship, my representation was directed to be considered.
who is placed, such representative of the petitioner shall be considered by an authority of the bank who is placed higher in office.
Then the
Acha,
accepting authority.
Then the accepting
Accepting
authority.
authority.
And so now what happened?
So after that, they communicated me the two APRs. After getting the APRs, I came to know that in one of the APRs, I was given 59 out of 100. And in another APR, I was given 95. And as per the promotion policy, the requirement was 60 in each of the years.
How much?
60.
60. So in
for-
one you didn't get.
In 1 year, I got 59. So for 1 mark, I was disqualified.
And these two marks are, these 2 years are 10, 11 and 11, 12. So in 10, 11 you
I
got 59.
And in 11,
And
12, I got
You
95.
got 95.
95.
And the qualifying mark is
60 in each of the years.
60.
There are other qualifying requirements also, but all those conditions are fulfilled. So
Right.
I made a representation, detailed representation saying that I don't have any representation for
Which
2000.
page I do, which page is the representation?
Representation
Just give me
Lordship,
the page number.
will mention.
Mr. Datta, you have the page number? Just the page number for the time being.
Lordship, representation is from page number 84 to 92.
All right. Yes. Then
84 to 92. So I made a detailed representation before the bank. That representation was arbitrarily and unfairly disposed of without any clear decision. It was neither rejected nor it was upgraded, but simply they said that there is nothing unfair in the APR. Whereas that's why I was telling Lordship, can
now,
you take-
however, it was the procedure that was laid down in paragraph subparagraph 3 of paragraph 25 of the order was followed to the extent that it was considered by an authority of the bank who's placed higher in office than the accepting authority.
it was
That
considered-
part you don't have.
It was not.
I understood.
Yes.
You see, the second part is the subjective satisfaction. As far as the first part is concerned, you do not have a
Yes,
grievance,
yes,
correct?
Yes.
Yes. Now,
So
where do we find that order? That is the order impugned in the present writ petition,
No,
Mr. Roy?
because thereafter another order was passed, that order I have challenged here. Because that order has been already set aside by this honorable court in my second writ petition. In fact, this is the third writ petition,
Oh.
Lordship.
Okay. Now, where do I find the second order of the writ petition?
Second order of the writ petition.
Second order,
Second order of the writ
because after this representation, they've already passed the order,
passed on order.
which was challenged in another writ petition.
writ petition.
Now, what happened in that writ petition?
That writ petition, actually, that order which was passed by the authority, that has been set aside. Saying
Where,
that
which
it is in page 58, Lordship.
50?
58. 58 to 83.
58. Now, operating portion of this order,
Operating portion of this order is paragraph 25 in page 81.
81.
Can I read, Lordship?
Yes, please.
Under such circumstances, this court is of the considered view that authorities did not consider fairly and objectively the representation passed by the petitioner while disposing it of by an order communicated through the impugned communication. Such act undermines the directions of the court. There is no dispute that no appeal or review was preferred against the judgment and order dated 11/8/2014, passed in the writ petition 3362/2012. That was my first writ petition, Lordship. As such, the judgment and order dated 11/8/2014 passed in the writ petition 3362/2012 had attained finality. The respondent authorities were therefore duly bound in law to carry out the orders as directed by the court. Such failure to comply with such directions and in the manner as directed by the respondent authorities can be viewed by this court to be contumacious. However, taking all facts and circumstances into consideration and in view of the fact that there is already a direction of this court.
Just 1 second. Under such circumstance, this court is of the concerned view that the authority did not consider fairly and objective. So what happened? What is, in which paragraph this court will find that they did not do exactly, why is it being said that they have not done it accordingly? In para 24 it is given. Oh, there is no application of mine in the order. Yes, okay. Okay. So then however, taking all that there is already a direction of this court. This court directs to re-decide the issues in the matter as directed earlier and pass an order giving reasons in support of such a decision as may be taken by the higher authority concerned. Yes, now what happened?
Now, Lordship, here I would like to mention one thing. While passing this order, this honorable court has also given a detailed direction of what is the meaning of an objective review. That, Lordship, I will kindly see from this page 76, paragraph 15. What are the essential requirements?
This order was not put to challenge by the other side
Yes.
before an appellate court.
No.
Yes,
Paragraph 15, page 76.
yes.
Taking into consideration the definition as extracted above, it is seen that for a decision to be objective, it must be rendered without bias or prejudice or disinterest, and as opposed to one's individual perceptions, feeling or intention. The decision maker must take a decision which is unbiased and quite independent of the personal emotions or perceptions of the decision maker. It must be a decision based on the essential facts, relevant particulars, and as per procedure laid down, which are to be resorted to be by such a decision maker while rendering a decision. Then paragraph 16. Lordship, I am reading from the third line.
Yes.
It is tried to mention here that time and again the apex court as well as the various high courts of the country, including this court, has laid down that administrative decisions must also be supported by reasons in order to enable a court.
Very well. This is a well-known proposition of law that the reasons must be there in the order. So as to the appellate court find out as whether the authority concerned has fairly considered the case or not,
Exactly.
applied mind or not. It is
Exactly.
only for that purpose.
Yes.
But
Yes.
it doesn't mean that the reasons can be something very perverse. It has to be based on the evidence, or there has to be some factual backing to that reason.
Yes, Lord. Yes.
Correct.
Yes.
This is what you want to
Yes, yes,
submit.
Yes.
Yes.
Then page 77, paragraph 19.
Yes.
Apex Court in Siemens Engineering and Manufacturing Company of India versus Union of India and others reported in, while examining the orders passed by the administrative authorities, has stressed the need for administrative order to be adequately supported by reasons. The Apex Court held that administrative authorities and tribunals should accord fair and proper hearing to the persons sought to be affected by their orders and give sufficiently clear and explicit reasons in support of the orders made by them. Then alone administrative authorities and tribunals exercising quasi-judicial function will be able to justify their existence and carry credibility with the people by inspiring confidence in the adjudicatory process. The rule requiring reasons to be given in support of an order is like the principle of audi alteram partem, a basic principle of natural justice which must inform every quasi-judicial process, and this rule must be observed in its proper spirit, and mere pretense of compliance with it would not satisfy the requirements of law. Then paragraph 20. Again, in Madhya Pradesh State Cooperative Dairy Foundation Limited and others versus Rajneesh Kumar Jamindar and others reported, the Apex Court held that it is well settled that when a power is exercised.
Right. This I've understood. Yes.
Yeah.
Now what happened then?
So, Lordship, actually what this judgment has said, essentially, that for a review to be objective, there must be a clear decision. Decision must be backed by reason. Reason must be supported by facts. My entire representation should be considered, and the review must be done by a
Yes.
higher authority with an open mind, fairly and objectively.
Okay, let's
Fair.
come to the impugned
But-
order now.
Nothing has been done. That
Let's
is the
see that.
problem, Lordship. Impugned order it is dated 14th of June.
Page
It is in page number, Lordship. It starts from 100.
100.
100.
Yes.
I come to the observations part only. Lordship.
Just 1 second. So directions, brief background. Yes, which page observation?
Observations are in page number 104.
104. This time it's a long order.
Long order. But that again, it is almost like repetition of what has been passed earlier. Nothing new here. Only a
Yes.
detailed elaboration has been given.
Yes.
Nothing objective, no material facts, no records, no evidences, everything based on surmises and conjectures something.
All right. Read.
So in paragraph 5,
Yes, sir. Yes, please.
subpara A, I am reading the last part,
No,
The-
you read this whole part.
whole part. Okay.
It is
It is
observed.
observed that the issue involved in the present case pertains to upgradation of APR marks awarded to the petitioner during the year 2010-11 It may be appreciated that awarding of marks in APR was done based on the assessment of the performance of appraisee by his superior to him he directly reported. The said assessment was further reviewed by his next higher supervisor to whom he may not directly be reporting. The year of APR in question pertains to 2010-11, that is about 14 years back. The reporting authority Muktiranjan Rai and the reviewing authority such and such in the present case have since superannuated. The petitioner himself since superannuated from the service of the bank. So the present reputation should be considered fairly objectively on the basis of records available in the bank. Now the fact remains, Your Lordship, even though they are saying that the reputation has been considered on the basis of materials and records available, in the entire order you will find that there is no reference of any record or any evidence, any facts. Everything is based on surmises and conjectures, or everything is based on ideas, and some vague sort of comments has been made. And moreover, one thing, Lordship.
But you see, Mr. Roy, you have to understand that now this court is not sitting as an appellate authority. This court has certain limitation while exercising the jurisdiction that you have approached. That is writ jurisdiction 226, right? It has its own limitation.
Yes, Lord.
Yes, of course, our arm, one can say the arm of the writ court is long enough to reach wherever there is an injustice. But nonetheless, there are certain limitations under which now this court cannot sit as an appellate authority over the order passed by the disciplinary authority. This court cannot appreciate or reappreciate the facts or the evidence. So you have to now the moment the order seems to, if the order appears to be backed by reasons, and it appears that there are evidence that is sufficient. Now, whether those were sufficient, the sufficiency may not be gone into at this stage. I am only indicating the limitations that this court will have. So you have to also make your arguments trying to come out from that situation and indicate that yes, this is a case where natural justice have been violated, where absolutely a perverse order or some law has been totally contravened, correct? Or the procedural statutory rules or act, something has happened. So this is what because you see, looking by it, it appears that yes, this time there are reasons. It is not that one-line order, which was on the last time which was passed. It is not that. Now it appears this runs through a lot of pages. In fact, the observation starts from 104 and it goes on till 108.
109.
That doesn't mean that only on that basis this court is going to affirm it. Of course, this has to be reasonable and all, but within that limitation. So I'm only indicating that to you so that
I understand.
so that
We'll come to the specific issue.
correct,
also,
correct,
and I
correct,
refer to
correct.
some judgments also.
Yes.
So can I go on reading these paragraphs?
Yes, please.
Then in B says.
Mr. Datta, this court is taking up the matter with an impression that the matter is ready for a final disposal.
Yes.
Because otherwise admitting the matter will only be putting it to a cold storage.
Your lordship may dispose it of finally.
This is the only purpose this court is investing the time.
Exactly.
So I'm just making it clear. Yes.
So paragraph B, during the relevant period 2010-11 for which APR score is the matter of contention, it is observed that petitioner was posted in controlling office, that is regional office of the bank. He was posted in regional office which was non-operational assignment, having no business target, for which APRF F2 form was submitted by Sri Devashish Rai. In accordance to his self-assessment, his job assignment was to assist the regional head in overall supervision and control of the business development of the region. So performance of Sri Devashish Rai could have been best judged by the reporting authority on the basis of former's assistance to reporting authority in overall supervision and control and assisting the latter in the business development of the region. It is also pertinent to observe that while awarding marks in the APR, an individual, the contribution and performance of the individual has to be kept in mind. Now, Lordship, when this order specifically says that the higher authority has to dispose of my representation with an open mind fairly objectively, this is a clear indication that the higher authority is relying more on the observations and findings of the reporting officer instead of he himself going into the details of my representation. Then in paragraph
Just one
3,
second, Mr. Roy. Bhargav. It was when- অলপ সময় লাগিব। সেইকাৰণে মাতিলে আহিবলে ভাল। কিন্তু চেঞ্জ হৈ নাযাব তেতিয়া। কাৰণে এইটো চৰ্চাত হ'ব।
my lord, can I
Yes.
take leave for 2 minutes?
Yes, yes, Mr. Atman.
Then paragraph C, it is observed that at the time of awarding 13 marks out of 20 in the key responsibility area under the head quality of performance, the reporting authority, while accepting the capability of the executing and discharging the job independently, has commented that he requires more penetration in tackling defaulted borrowers of all segments. It is further observed that from the self-appraisal part filled by the petitioner, that he himself has mentioned that the areas where he did not feel to have performed well was surfacey final execution. Therefore, the marks awarded by the reporting authority cannot be said to be arbitrary or without any basis. Now, Lordship, I will take you kindly to page
What does surfacey final execution mean?
final execution means selling.
Huh?
Selling the property. Finally, after taking possession, selling of the property. Now, my problem was, I have also mentioned it in my APR itself. Problem was mostly we are having rural branches. Now, in rural branches, it is very difficult to get even physical possession also. And even if you take physical possession, hardly you get a buyer to sell the property. So that was the reason. And it has been accepted by the authority also.
So there,
But there also,
you
but
said
there-
you did not feel, you do not feel to have performed well.
yes, that I am
That
admitted.
you have admitted.
This was the area where I could have,
And that
performed.
is indicated in which page?
This is indicated in my self-appraisal, Lordship. Page 50, Lordship. Page 50, in the third paragraph, job responsibilities allocated, etc. You will find I had mentioned.
Just
surfacey
read.
Surfacey final execution. Reasons or constants for not performing well, I wrote vulnerability of the areas, very poor asset disposal scope in villages, though in semi-urban areas, some success could be achieved.
Okay.
Now, interestingly, Lordship, here also,
Hmm.
you will find very good. They are saying that they have given me, this is the mark they have given in page number 49. Quality of performance, very good. Page 49, quality of performance, very good. They have
Hmm.
given me 13 out of 20.
Yes,
Next page, in page number 53,
yes.
you see the mark gradings are there. Outstanding, it is 85 to 100%. Very good, 72 less than 85. Good, 55 to less than 70.
Very good is how much?
72 less than 85. 72 less than 85. So in that case, Lordship, I should have got here, I guess, very good. I should have got minimum 14. 70% of 20 in page number 49.
You're showing it from page 53 initially, na?
Page 53 is the mark grading that has been given.
70 to less than 85.
85 out of 100. Very good.
And this, their marks you find
In
it at
49,
page
page 49.
50.
Page
Page
49.
50.
Page 49, Lordship.
Yes, no, that 13 mark is at page 50, I think.
No, Lordship, it is in 49.
Huh?
49, page 49. Quality of performance.
Very good. 13.
13. I should have got 14 here, Lordship.
This was by
70%.
the reporting authority, and the reviewing authority also gave the same.
Same.
Yes. Okay.
So I am disqualified, Lordship, for 1 mark only. So if this 13 is corrected to 14, then I am qualified. This is the arbitrariness, Lordship.
Hmm.
Now, Lordship, then in paragraph B, again I am going to page 105. It is further observed that the reporting authority has awarded 6 out of 10 marks under the factor quality of judgment and decision. The reporting authority, while awarding marks under the said head, while finding the performance under the said factor to be satisfactory, but commented that he is sometimes apprehensive for which result is adversely affected. Therefore, the marks awarded by the reporting authority cannot be said to be arbitrarily or without any bias on this count. Now, they are saying that I was apprehensive, sometimes apprehensive, for which result was affected. I have also submitted my performance report. It is almost 100% targets have been achieved in almost all the parameters. But this is only a subjective observation, Lordship, that I was apprehensive. There is no such instance. Never before I was ever informed that I was apprehensive. Even there is no such record also to prove by the management that because of my this type of attitude or my apprehensive nature, results were adversely affected. But they have made a comment. And another interesting thing, Lordship, they have given me the observation satisfactory. Now, where from the satisfactory word has come? In our admits, even in that
And for
marking system,
satisfactory, what is the grading?
what is the, how they have given me the marks
No,
against
no.
satisfactory?
Otherwise, what is the standard grading?
There is nothing like satisfactory in our administrative parlance.
In that page, there is nothing like
Nothing like
satisfactory.
that.
There's
Only
very
conditions,
good.
only conditions are outstanding, very good, good, average, inadequate.
Oh, there is no satisfactory.
Nothing like satisfactory. Then, Lordship, in E, it is also appreciated that while awarding marks under any head, factor, reporting authority is likely to have a comparison of the actual performance versus contribution of the individual with the contribution performance expected by the reporting authority from him under each factor. Now, what was the expectation? In our case, Lordship, what I understand, our expectations are the targets are given. We have to achieve the targets and some other due diligences like discipline, punctuality, etc., we have to maintain. Now, if they had any other expectation which they could not disclose and which they cannot even now disclose, that is their problem, Lordship. They have to say what are the expectations which I could not
All right.
perform.
Next, F. One of
Then
the
F,
content.
one of the contentions raised by the petitioner is being awarded 3 out of 8 marks under the honesty and integrity. It is observed the marks 3 out of 8 is awarded under the factor leadership while evaluating managerial dimension of the petitioner. There are various indicators mentioned therein for assessing reporting authority, for assisting the reporting authority while evaluating the appraisee under the said factor. That is, integrity earns esteem, respect from the subordinates.
Just one sec, Mr.
No.
Roy. Just one. Mr. Datta, because before going further, this court just wants to ask you one question. Looks like that this person has, because of 1 mark,
Right.
right? He's not getting the promotion, not the benefits.
That's fine. But the entire period has been.
But for that one mark. But if we go by number C, where the grading is very good,
Yes.
correct?
Yes.
Now, if you go to page 50, what is very good? Page 53. Very good is, if you see, they have given the marking for very good. That is from 70 to 85. Correct?
Yes.
Now, what is the mark given at page 49? Against very good.
13.
So how 13? If it is very good, the mark should have been between 70 to 85, isn't it?
Yes. No, your lordship
No,
will see one
No,
thing.
I am only on this right now.
Well-
I am not taking the rest of the things immediate. We'll obviously hear everything, but why here 13 when you are saying very good?
13
You could have said
is,
poor,
is given by the reporting authority.
but accepting authority has accepted.
Now, what is in the mind of the reporting authority? Nobody knows.
No, but we know it says very good. That is very good. That is why the markings are given.
Yes.
You see, very good doesn't mean you say very good and give 1.
No, that's
Correct.
That's our
Absolutely. But if you go, let's turn back to that page once again.
104.
Yes. 53, right?
53 and
53,
49.
see, very good is given, no? The number, first is inadequate, average, good, very good, outstanding. These are overall assessment, please
Yes.
take, right?
Yes.
But the marks are given down. So this is like a standard which you follow. That when you say very good, you will give something between 70 to 85, right? Now, after giving all these marks, you finally do an overall assessment.
Yes.
And then whatever comes, you put it here. Now here, this is how I understand.
Right.
If it is otherwise, you are free to tell me the procedure. But I understand it in that manner. Now, in page 49, against quality of performance, it says very good, capable of executing, discharging the job independently, does not need much supervision, but what is it says, but needs more penetration
In tackling
in
default
tackling
borrowers.
defaulted borrowers
Of
of
all
all segments.
Well,
And therefore, you see the grade, what is in the mind is also of the reporting officer is also clear. And accordingly, reporting officer says very good.
and then, my lord, this is supported by his own self-assessment.
We'll go to that. That is not against this, right? That self-assessment. Yes, you see, but you see, Mr. Doctor, even for the self-appraisal, you have to understand what he said because because of the rural background of that particular location, he could not get the final execution done. This was beyond his because of the situation he's there. And this is why the authorities have acknowledged. They said capable of executing, discharging the job independently, does not need much supervision, but need more penetration in tackling defaulted borrowers of all segments.
Yes.
So that is why it's
So
not,
that
it
is
doesn't
the-
say outstanding.
Minus point remains there.
Correct. So that, but that doesn't mean now you will give him only 13 because you are saying very good. I could have understood you gave him 50 also.
The question would be
No,
whether.
but you see, this is strikingly, it's looking unreasonable at this moment. Now, the moment something is very shockingly unreasonable, then of course this code perhaps can enter into this realm. Otherwise, this code is not going to enter into the grading area in that part, isn't it? Because this is
Your lordship towards a PESCO decision in this
no,
particular
but
subject.
on this, what is your specific instruction in your affidavit on this point?
Yes, that.
Why? Because this is a point that they have alleged. Now, what is your answer to it? Because this is one of the most criteria, even if we don't go to the others.
Lord, if I take your lordships to our affidavit.
Only on this,
let me clarify
because
the-
I am yet to hear the petitioner in length. But on this, what are you saying?
My lord, your lordship kindly see at.
Where is that
One for-
self-appraisal where you have said about page 50?
Self-appraisal is in page, that is page 47 to 54.
Page 50, your lordship kindly.
Where is that comment that you have given?
That is in page number 50, lordship.
50. 50, right?
Surface final execution, your lordship.
Where do I get that? The
Yes,
region
In the middle part.
achievements.
No, in the.
So
left-hand
I
side,
got it. I got it.
surface-
Surface final execution, vulnerability of area, very poor asset disposal scope in villages. Though
Though in semi-urban areas, some success.
some
could be achieved.
success could be achieved. Yes. You cannot, it's indicating that there is some biasness from this point. Only that much I'm just, you see,
Now,
you
in that
have
regime,
to
Lord-
demolish that anxiety of the court with facts, but I am indicating at the outset
Yes.
because he has been very fair.
If the
In his
question
own,
has
in
been
his
come-
own self-appraisal, he has been fair. He fairly assessed himself. And looks like the reporting authority has also acknowledged that and said, yes, He's good, very good.
Now, if
He
my-
doesn't need all this. He is capable.
if the
Only thing because of
petitioner-
that defaulter. Now, defaulter thing goes back with his own self-reprisal about that rural stationing.
No, that.
Now on that, I am on only on this. Now, when you are saying very good, the marking is given, then why 13? Why 13? And there could be some answer because you see satisfactory, you give 7. Now, in this grading, satisfactory is not 7. So what does this indicates? There is no satisfactory only in the grading. Good is 55 to less than 70. So when these markings are given, on what basis are these markings given, Mr. Datta? The
Mr.
13, 6, 7.
Your lordship can see, so far, very good is concerned, he got 13. Now it is with a rider.
That I've understood.
Then satisfactory in the second part, your lordship will find the quality of judgment.
No, that's okay. What I'm saying is that on what basis are these marks allotted? This 13, 6, 7.
That is, my lord, the reporting officer assessed his performance.
So how do you fix this 13? 13 out of what? Out of 20?
13 out of 20.
Correct.
It's not a very bad mark. It's a quite good mark.
So there is nothing like no for any guideline to this. So based on basically these very good satisfactories are misnomers here. Looks like that is only an indication of saying that yes, he's very good, but these are his shortcomings. This is like that, I think.
So far,
Because
my-
ultimately the overall assessment has these words:
Yes.
outstanding, very good, good, average, inadequate.
Right.
And there the markings are given. So after going through all the assessments and the remarks, if the reviewing and if the reporting and if the reviewing authority is of the view that yes, he falls under very good or he falls under outstanding, then the mark awarded is between 85 to 100. I think it is in that manner.
Yes, the review authority has concurred with the report of the,
All right. Yes,
Report
Mr.
is-
Roy, coming back to you.
and in regard to bias, my lord, if that question comes.
All right. All right.
There is no allegation.
All right,
there is an
Mr.
allegation.
Datta. All right. Yes.
See, even in marking also, since you have referred this point, I'm just again, if you can kindly go to page 49. Two satisfactory, even though there is nothing like satisfactory in our administrative book.
You see, Mr. Roy, in the word satisfactory, very good that is mentioned here are the the remark columns, correct?
Yeah.
Now here one has to define prioritizing of work and future planning. There any word can be given. It is not
Yes,
needed to
yes.
be in this list of overall assessment. It is
agree.
not like you pick up either outstanding or inadequate and put it here. That
I
is
agree.
that
I
is
agree.
not the
I
criteria
agree, Lordship.
because the marking is out of 20, 10, 10, 10, right? Now here they will make an assessment of you.
I
And they
agree.
will give it. If you are good, they will say you are good. If they say that yes, if they may feel that yes, you are good, but they might feel that no, though you are good, you might have to have a little bit of improvement. Then, because I'm
Yes,
sure you must have also done all this in your service career.
Yes, Lordship.
Correct. This is how it has to be done.
What I am telling.
Now,
Lordship,
the only thing is that on this basis, you give these markings. Out of 20, you give the marking, right? Now, when you look at the comments of quality of performance and you compare the marking, it doesn't look arbitrary because it is 13 out of 20.
But that
Okay.
transferred to 65%.
Correct. But you
But then
see,
very few-
now ultimately one has to look into 13, 6, 6, 7. That is 32. Correct. Now the 32, and then from here, the ultimately all these marks has to be taken together and then finally see where you will fall. So
I-
here, I think ultimately you fall under where from a very you came in good. You came
You
under
gave me
good.
59, so it is good.
You've come under good. That is why it's ticked.
Right.
Because grand total is 59.
So what my.
Now that is now you see, Mr. Roy, this court cannot now correct 13 to 14.
Lordship, my point is, in their own This as per grading.
Hmm.
Very good should get 70 to 85%.
That I am not accepting, Mr. Roy, because you see, I have just now demonstrated
Yes.
that cannot be. That very good is out of 20, one have to give a mark. He could have not even used the word very good. It is an idea. The reporting authority knows that you are very good, but he's indicated the shortcomings. And you yourself also admitted that, yes, I have done my best, but you see, these are the problems. So there were certain shortcomings, unfortunately. And that is why you got 13 out of 20. It is not a case that you got 4 out of 20 or 5 out of 20. You got 13. Now, how this court, in exercise of Article 226 jurisdiction, get into that area of the experts and correct that 13 to something else? Because it doesn't look unreasonable to the mind of a reasonable person, in the eyes of a reasonable person. Yes,
Yes.
someone might think, okay, I will give him 15. That is also okay. Someone might say, no, I'll give him 12. That is also okay. You got 13. Unfortunately, you missed the bus by 1 mark. Unfortunately. But then, you see, these are areas of subjective satisfaction at the end of the day. They have done it. Unless you point out something very strikingly arbitrary, because that's what you are trying to demonstrate by going into these marks and all, will not take you anywhere. You have to show something more.
I'll come to that later.
You understood what I'm saying?
Yes, yes.
Because let's not get into all the marking area, because it appears they have the discretion. They have accordingly given you the marks.
But then Lordship, very good.
Now, if something they have not done, say for example, on the first occasion, they did not even give you reasons. That cannot be. That is why the court sent it back. Now they have given reasons, but suppose those reasons appears to be totally perverse. Suppose there are no evidence at all. Then you show.
That is exactly my.
Then show, but not into these marking. You've understood.
I understand.
Because there is no point in going to that area.
I understand.
Yes.
So, Lordship, here they have said that he is sometimes apprehensive. Now, where are those evidences? There is nothing on record. Never before I was even informed. Then, paragraph
Where is that word apprehensive?
It is
In paragraph D.
paragraph D, Lord.
D, right?
D.
Yeah, sometime apprehensive. Yes.
Paragraph F. One of the contentions raised by the petitioner is being awarded 3 out of 8 marks. So that I have already read. Now, here, Lordship, you can see, if you see that appear, it is page number 51.
Page number
Page number 51.
51. Yes.
The second parameter, leadership,
Hmm.
honesty and integrity, they have ticked it. And against this honesty and integrity, out of 8, they have given me 3 marks, which comes to 37%. And in that form itself, Lordship will find that it is written, in case of adverse views, please specify. Now, if they have given me 37% marks in honesty and integrity, there is nothing on record. In fact, Lordship, just for information, nowadays, because all these affairs are also done in the system itself, these honesty integrity column mark is made by default by the system itself. So if 8 marks have been assigned against the honesty integrity, system will by default assign 8 marks to all the officers. Now, reporting officer has a discretion to change that mark. But if he wants to modify that mark, immediately
has to be there.
another field will appear.
Something
And
has
in
to
that,
be there.
He has to specify. Otherwise, it will not allow him
As
to proceed.
why?
Why he is this reducing the mark from 100% to less.
Okay.
Now, here
Noted.
they have given me
Noted.
three marks out of 8, but
Noted.
nothing is given, no reason is given. Then G, it may be noted that assessment of an officer performing the role of incumbent of a branch or regional office was done based on the business target achievement, whereas assessment of an officer working in support role in regional office was done based on the performance assessed by the reporting authority, and assessment of an officer working in training center was done based on ability to impart training and deliver the lectures. It is observed that officer performing the role of providing assistance to regional manager in overall supervision and control of business development of the region should work in various areas such as driving and monitoring business development, follow-up on control measures, providing support to branches under the control of the regional office, etc., as per guidance received from the RM, and the performance of such officer can be better judged by the respective reporting authority. Here also, this is an indication, Lordship, that the reviewing authority is relying on the
Reporting
observations of the reporting officer. Now, interesting thing, Lordship, here, if you see that I have also attached here my business, the targets and achievements. That is, we call memorandum of understanding statement. What are the page 93 to page
93 to page 99.
99. So here, Lordship, everything is in record. What are the targets given by the head office and what was our achievement? And Lordship will find that in almost all the parameters, either we have exceeded the target or almost 100% achievement has been there.
All right.
Now, interesting thing, they are not denying my role, but they are saying that it is a collective achievement, so I cannot be given any credit.
All right. Next.
Then next,
H.
H. From the above records available, it is further observed that employee received higher APR score for the year 2011-12, 12-13 and 13-14, that is 95 in each year. So in all these 3 years, I got 95. It is observed that during the said period, Sri Debashish was on deputation as faculty at IIBM Guwahati. It is worthwhile to observe that APR marks of Sri Rai in the year 2006-07 was 75 when he was working in Guwahati branch, and appraisal was subjective, having no business target. APR marks of Sri Debashish Rai in 2007-08 was 48.2 when he was working as an incumbent of Nagaon branch based on the achievement of the business targets, though APR marks for the year 2008-09 working as incumbent Nagaon branch and 9-10 are not available. They are admitting, Lordship, these two APRs are not available in the bank.
You want a glass of water? Yes.
So they are admitting here that APRs for 2010 and 8-9 are not available with the bank. And they are making a reference of APR marks of 2007-08, where they say that I got 48.2. Now here again, interesting thing, Lordship, this APR was also not communicated to me. And in 2009, I was promoted also. Now I have already quoted a judgment in the petition itself. It is Badrinath versus Union of India.
Sorry, I didn't get this. 2009, you were promoted.
2009, I was promoted in December 2009. And they are making a reference of my APR for 2007-08, saying that I got 48.2 there. So once I've been given a promotion.
These are too factual. Can this court get into this factual aspect?
No, this is mentioned in that order.
These are too factual, Mr. Roy.
No, Lordship, they are mentioning it in the order. That's
correct, but you see, this court cannot get into
No,
this factual area.
I'm not saying before this court to consider these aspects. I'm just
Why
taking
you
a
have not engaged a lawyer in the matter, Mr. Counsel? Mr. Roy?
It took me too long for the previous litigation to be completed from 2015. up to
No, but
2000.
only thing is that you see, they are trained in that
I understand.
manner.
I only hope and pray that Lordship will
No,
my deficiencies.
No, not that. It's not that you're doing it very fine, but you see, maybe
Not in the proper way.
No, I'm not saying that it is not proper or right or proper. You're doing excellently, but sometime, what the lawyer could do for you, you may not be able to do that for yourself.
I agree.
Because they are the qualified experts in the field. That is why the lawyers are always presenting the cases of the litigants before the courts, right? Some tribunals of experts, where experts are experted, things are going on. There it could be an exception where experts from those fields are allowed to present because they know more. The lawyers will only know the technicalities. Factual, of course, you will know because you're the concerned person. But those facts, the lawyers knows how to place it before the court, right? And that is for your benefit, not for anyone else. It is for your benefit alone.
And
Anyways, yes.
so, Lordship, then paragraph I. The petitioner has further contended that he placed on record his business performance of all parameters that I have already mentioned that this MOU statement, what I have said, they are saying that it was a collective achievement, so they are not interested to give me any credit for that. Then in paragraph J, at this stage, it is pertinent to note that when the representation dated 10/10, that is my first representation, was being considered by the Executive Director of erstwhile United Bank of India, clarification was called for from the reporting authority, who was then in service in the bank.
Okay. And that have come now. Conclusion
Conclusion is in
108.
108.
108.
108. Shall I go to the final part, Lordship?
Yes.
So final part, it says in 109,
After going through.
after going to the facts as mentioned above and looking to the appraisal evaluation process, where performance of an employee is evaluated by reporting authority and subsequently reviewed by the different authority whose rank is higher than the reporting authority, I am of the view that the concerned officer, Sri Rai's performance evaluation seems to be appropriate. Now, Lordship, the direction of the court was very, very specific that my representation should be considered. But what they have done, they are saying that they have considered my APR and the APR is fair. And there also, my specific issues has not been replied as per this petition. Whatever issues I referred. Now, Lordship, I'll submit before you some of the judgments to further support my claims. So if I may,
Paragraph 6,
paragraph,
page 108. This is in reference to your contentions.
paragraph 6.
Yes.
The marks awarded during the previous period as well as
Page 108, paragraph 6.
Conclusion.
The conclusion.
from the first part I'll read.
Yes, just read that this she so and so was working as so and so. And then
And
and
it's awarded?
saying she so and so has raised his contention that the marks awarded during the is not correct. The petitioner
petition-
himself so and so. The role. So this is in basically in response to what you have
Exactly.
put in your representation. So you cannot say that it doesn't look like that it is not considered. Ultimately, after considering all this, the looks like prima facie, it looks like that the authorities concerned have accepted the gray marking given by the reviewing authority.
Lordship, I
It,
have
it
read,
appears like that.
Lordship,
I have to look into the details of the case myself, but
See,
it looks like.
I have made representation for upgradation of marks in 8 different parameters, giving specific points.
So each of these have not been considered.
Nothing
you're
has been
saying.
considered. Only 2 has been considered here. Rest of the 6 has not been even touched.
Okay.
So, Lordship, I'll come
Where
to
is
some
your representation? Let's go to
representation.
that.
It is there. Lordship. Representation is from page number 84 to 92.
Just indicate according to you which are the paragraphs of this representation which you said was not even touched by the impugned order. You said out of only 2 have been considered, but not the others.
Paragraph 87, Lordship. This leadership.
Paragraph 87 or page 87?
Page 87.
Page 87, yes. The
Leadership.
managerial dimension, that part.
Managerial dimension, leadership,
This, according to you, they have not
they
considered.
have not considered. Then the
Yes.
last paragraph where I have given a comparison of how marks were there in the previous 2
Well,
years.
let me just make a note of it. Yes. Mr. Datta, you have to just answer to the specific
Correct.
point. That's why I'm just indicating. And which one? The page 88.
Page 88 also.
That leadership, decision making and all
Public
that.
relations, marketing skill.
This part they have not considered
Yes, they have
according
not
to you.
considered.
Yes.
The Lordship, am I allowed to make some references of the judgments?
Yes, please. Are you having photocopies of the judgments?
Yes.
Yes.
First judgment, it's Manoj Kumar versus Union of India and others. The judgment, division bench judgment of the Honorable Supreme Court. Here, this Honorable Court has said not only illegal.
You have a copy for the other side? Have you given them or the list of cases? Yes.
So here, Lordship, it says that not only arbitrary and illegal orders can be interfered by the court, court also has taken upon itself the responsibility of restituting the damage that may be caused as a consequence of such arbitrary orders. I just
Okay.
come to the operating.
Just tell me first indicate the paragraphs you want to rely.
Paragraph, Lordship, 19,
19.
page number 10 of the judgment.
Okay, 19.
We are of the opinion that while the primary duty of the constitutional courts remains the control of power, including setting aside of administrative action that may be illegal or arbitrary, it must be acknowledged that such measures may not singularly address repercussions of abuse of power. It is equally incumbent upon the courts as a secondary measure to address the injurious consequences arising from the arbitrary and illegal action. This concomitant duty to take reasonable measures to restitute the injured is our overreaching constitutional purpose. This is how we have read our constitutional text, and this is how we build our precedents on the basis of our.
This is what point? This is on what? You see, decisions are contextual. So we have to understand
The context.
the context, in which context
It was an
what has been.
employment case. It was an employment case.
It was a.
Employment related case.
This is only after if I've understood it correctly, it is not only setting aside but also molding the relief. In short, this is what it says, right?
Yes, Lordship.
Okay.
Then Lordship, then there is another second judgment is Narendra Prakash Kohli versus Union of India.
Yes.
Here Lordship finally come to
ACR on. This is on ACR.
ACR,
This is from New Delhi, Delhi High
Delhi
Court.
High Court, division bench judgment against Lordship.
Yes.
Come to page number 12, paragraph 23.
23. What is the point?
The sudden drop in performance.
For which point do you want to rely
Because
this?
if you can see my representation, Lordship.
No, just indicate the point.
I
Point.
have mentioned that in 3 parameters, marks in the previous 2 years and following 2 years were outstanding. But in that particular year under dispute, suddenly there is a sharp fall in the marks. And there is no justification given why there is such a fall. So this judgment, Lordship, shall I read paragraph 23?
Yes.
In page 12. The sudden drop in performance on these attributes for the appraisal period 2008 to March 2009 from very good. As a matter of fact, if one closely sees, analyzes the traits on the various parameters, when profiled in the two preceding and succeeding ACR performance, one can safely say that petitioner is actually bordering towards being appraised excellent to average. So this is within bracket. So this gradation from very good to average is enough to raise the eyebrows on the fairness of
Which
the petition.
page do I find the earlier appraisals of yours for the earlier years?
Earlier appraisals are not here, but I have in my representation, I had given the marks. In
Mr.
those
Doctor, do
parameters,
you have the copy of the earlier appraisals?
I can bring it.
Is
up.
there any sharp fall of the grades?
No, my lord, this is not the thing, my lord, my.
No, I'm just asking in case you need to respond to that. Anyway, yes, Mr. Roy.
My
Let
lord,
him finish. Let him
only
finish.
one parameter.
Let him
He
finish.
could not explain, my lord. Now, he was in the regional office at that relevant time, 2010-11.
Anyway, let him finish.
Yes.
Yes.
Lordship can kindly see page 88. There I have given in the tabular form what are the marks in the previous 2 years and in the
Page,
following- Page 88.
Page 88. That is of your representation.
Yes, Lordship.
All right, it's okay. I just wanted the note. Yes. Next case.
Then
This is again of Delhi. Yes.
in the same judgment, Lordship, page 19.
That I have seen. You have marked it. Yes.
Then Ajit Kumar and this next two judgments,
Yes.
Ajit Kumar and Manudev Dahiya, these
Yes.
are the two judgments the respondents have referred in their affidavit, claiming that administrative orders cannot be interfered by the court. But from the same order, Lordship, I will prove that it has been a misinterpretation of the order. Because in the Ajit Kumar case,
You want to give your reply before?
no, I can give it later. on.
No, in
So I
case
can skip it now. I can skip it
because
now.
today they may not even press these two decisions. We don't know what Mr. Datta is going to do
then-
today.
I keep it
So
pending.
because you have a right to reply.
reply. Yes, I'll reply on this
Yes.
too.
Then
Then there is a judgment of R.K. Jivan Lata that again relates to my final prayer before this court. This lordship is pleased to give me that relief. In this Jivan Lata Devi versus High Court of Manipur judgment, division bench of the Honorable Supreme Court, there are series of judgments in this regard, lordship, but this is the latest one in 2024, where the Supreme Court division bench has said that uncommunicated SCRs cannot be considered. It has to be ignored for the purpose of deciding qualification in promotion process. And in fact, in this instant case, lordship, if you see, 4 years were under area of consideration for promotion. Out of those 4 years, 2 years APRs were not communicated where the petitioner got less much. So ultimately, the Honorable Court has said that those 2 APRs should be ignored and eligibility should be decided on the basis of the residual 2 years of APR from the zone of consideration. So if the same logic is applied, in my case also, because it is admitted fact that I was disqualified on the basis of uncommunicated APR. So if that uncommunicated APR is ignored, on the other year I have got 95.
no, but which your appraisal was not communicated to you?
Both the years APRs were not communicated. The communication was only after this judgment of this Guwahati High Court.
So it has to be first communicated,
That is the legal position, lordship.
and admittedly it was not communicated.
Because of- The promotion process was held in 2012 and the communication was made to me in 2014 after this judgment. of this-
Promotion was when,
In 2012, May 2012.
and communication was
In, I think it was in September 2014, after this judgment of this Honorable Court,
first judgment.
first judgment. The judgment was in August 2014.
Yes. So ultimately, in Jibon Lata Devi, what did the court do?
Court said that because the 2 years
This is Apex Court.
Apex Court, lordship.
What did the Apex Court do?
Apex Court says that out of the 4 years under consideration, zone of consideration, 2 years APR, High Court also admitted that they were not communicated. So the Apex Court says that those 2 APRs should be ignored. And eligibility should be decided on the basis of the residual 2 years from the zone of consideration. So if you can see, lordship.
So in your case, what will happen?
In my case, lordship, the zone of consideration is 2010-11, 11-12. So if 2010-11 is ignored, then in 2011-12, I got 95, lordship. So I am eligible.
But
Because
that
because-
also not
That
communicated.
was, but that requirement of 60 is fulfilled there.
So there is nothing adverse. So
Disqualification.
that way there you are not prejudiced.
I am not prejudiced. Because disqualification cannot be on the basis of uncommunicated. In that
Okay,
case, even
understood.
in 2009 also, I was promoted on the basis of uncommunicated. APR.
Understood.
And finally, lordship, there is a judgment of, again, it was a larger bench judgment.
Abhijit Ghosh.
Abhijit Ghosh, the Siddhar, where here also in a similar case, even after retirement also, all benefits are
retired?
given. I have already retired, lordship.
Yes.
That is why I am pending my case. I
Yes,
have enough
yes.
time. So,
Yes.
so here in this Abhijit Ghosh Dassidhar case, all the retirement benefits were given, except the in-service benefits because he did not perform higher duties. But in my case, that is also not applicable because Lordship from 2011 to 2016, I have 2022, I have worked as a faculty.
Okay. Let us hear the respondent. Yes, Mr. Datta.
No, my lord, your lordship will first see how the assessment is done. Now, assessment is three kind of assessment here. The first, my lord, he was supposing in he is the incumbent in the branch.
You may take a seat. Yes, you can have the water.
The branch.
Yes.
Then his achievement he has done in the bank, that will be performed by the reporting officer.
That would be,
That will be assessed by the reporting officer of what marks he can be given. Now, in these cases, at the relevant time, he was a regional officer. He was assisting the regional officer. Now, his performance can be assessed only by the reporting authority. My lord, he is the best person, and the appeals court time and again has said no other than the reporting
rather than the
officer.
reporter.
Because my lord,
Because he's the most, he's acquainted
he is the only person, my lord.
with
Supposing now-
the kind of work that is
Yes,
being performed.
Exactly, my lord. As a lawyer, my lord, we have so many juniors. We know out of the 6 or 7 juniors who is the best.
And on the basis of those marks, the reviewing authority will see whether,
Exactly, my lord.
in
And-
terms of the, because those marking will
Yes.
have to be indicated on what basis.
Yes, yes,
So that if something seems to be unreasonable or not correct,
right.
then the reviewing authority may review it, correct?
Question of arbitrariness comes and the review authority will look into that. Now it's
Ultimately, that is the accepting authority,
right.
right?
And yes.
Sometimes there could be another,
Another authority also.
reporting, reviewing,
Review and the final
accepting.
authority. Now here, the review was the last authority. And the third kind of assessment, my lord, supposing he got 95, he did exceedingly well when he was the, my lord, he was a training which staff he used to impart. Now in there, he did exceedingly well. So he got 95% in the two years. no? Now, therefore, these cannot be counted while assessing his performance here. His performance in the year 2010, 2011, you lordship will find, he was playing the role of assisting the regional officer. And the regional officer, he was the reporting officer, and he used to assess his performance. So those are the things, my lord, my learned friend has not, my lord, elaborated. Then, my lord, your lordship kindly see page 49, my learned friend wanted to show that in integrity and honesty, he was given 3 marks. My lord, that understanding was not correct
40?
at page 51.
Yes.
In second column, your lordship will find leadership. Now, he explained that integrity, honesty and integrity, he was given 3 marks. It's not in fact integrity and honesty. The head is leadership. In the left-hand column, your lordship will find.
Overall,
Overall,
there are 1, 2, 3, 4, 5.
yes, your lordship will find the head
Everything
is,
together.
yes. It's not that only merely because it is ticked, then your lordship will find others are not ticked.
But it seems that there is nothing otherwise mentioned, but why answer of 8 and 3?
Now, this-
But of course, this is not something that this court can get into, right?
These are the, my lord, factual aspect of the thing. Whether it comes within the domain of your lordships is another question. But I respectfully will say that your lordship will not go into all that because the decisions laid down with the appeals court is very clear. And I'll skip.
So
all
this
things.
leadership is honesty and integrity, then earns esteem, respect from subordinate,
Right.
willingness to assume responsibility and responsiveness to corporate concern, able to motivate people working under him, empathy towards colleagues.
Now these are the these parameters, my lord. Only the reporting officer can say exactly what had happened. Now, if it sent back to some other person has been retired now. Now, only on the basis of the records available, they can say. Now, if it comes to your lordship, my lord, how we can your lordship can assess his performance at that relevant time. It is well nigh impossible, my lord. So therefore, my lord, the speaking order, as your lordship has seen, I will take your lordship there. They have explained very categorically, my lord. I'll take your lordships to page 104, the observations given by them.
Mr. Datta, you
Ma-
want water?
The-
You want water?
No, it's all right.
Yes.
Up till now, it's okay. My lord, observation, clause A, your lordship can see.
Clause
A,
A.
capital A. It is observed that issue involved in the present case pertains to upgradation of APAR. Marks awarded to the petitioner during the year 2010-11. It may be appreciated that the awarding marks in APAR was done based on the assessment of the performance of the appraisee by his supervisor to whom he directly reported. The said assessment was further reviewed by his next higher supervisor to whom he may not directly be reporting. The year of the APAR in question pertains to 2010-11, that is about 14 years back. The reporting authority Sri so-and-so and the reviewing authority so-and-so in the present case have since superannuated. The petitioner himself has since superannuated from the service of the bank. So the present representation could be considered fairly objectively only on the basis of the records available with the bank. No, my lord, it is the reporting authority.
Got
He
it.
assessed
Yes,
everything.
yes, understood. Yes.
Now, during the relevant period, so and so for the which the APAR score is the matter of contention, it is observed the petitioner was posted at controlling office, that is the regional office of the bank. He was posted at regional office, which was non-operational assignment, having no business target for which APAR F2 form was submitted by Sri so and so. In accordance to this self-appraisal, his assignment was to assist the regional head and his reporting authority, so and so, in the overall supervision and control of business development of the region. So performance of this so and so could have been best judged by the reporting authority on the basis of former's assistance to reporting authority in overall supervision and control and assisting the latter in the business development of the region. It is also pertinent to observe that while awarding marks in APAR of an individual, the contribution and performance of the individual has to be kept in mind. It is also observed that at the time of awarding 13 marks out of 20, the key responsibility area under the head quality of performance, the reporting authority, while accepting the capability of executing, discharging the job independently, has commented that he requires more penetration in tackling defaulted borrowers of all segments. It is further observed from the self-appraisal part filled up by the petitioner that he himself has mentioned that the areas where he did not feel to have performed well was surfacey final execution. Therefore, the marks awarded by the reporting authority cannot be said to be arbitrary or without any basis. It is further observed that the reporting authority has awarded 6 out of 10 marks on the factor quality of judgment and decisions. The reporting authority, while awarding marks under said head, while finding the performance under the said factor to be satisfactory, but commented that he is sometimes apprehensive for which result is adversely affected. Therefore, the marks awarded by the reporting authority cannot be said to be arbitrary or without any basis. It may also be appreciated that while awarding marks under any head factor, the reporting authority is likely to have a comparison of the actual performance contributions of the individual with the contribution performance expected by the reporting authority from him under each factor. One of the contention raised by the petitioner is being awarded 3 out of 8 marks on honesty and integrity. It is observed the marks 3 out of 8 is awarded the factor leadership. While evaluating the managerial dimension of the petitioner, there are various indicators mentioned therein for assessing reporting authority while evaluating the appraisee under the said head factors. The integrity earns esteem, respect, from subordinate. Now, these are the things your lordship has already seen.
Yes, this I've seen. Yes.
Then G, your lordship, this is important.
I've read G.
It may be noted that assessment of an officer performing the role of incumbent of a branch or regional office was done based on the business target achievement. Now, if he is posted in the branch, well, he is dealing all the business transaction. So, my lord, his performance will be assessed by the authority on the basis of if he does exceedingly well in the business achievement. In that case, that mark will be assessed. Now, in this case, my lord, he falls on these, whereas assessment of an officer working in support role in regional office, he was performing support role in regional office, was done based on the performance assessed by the reporting authority. An assessment of an officer working in training center was done based on the ability to impart training and deliver the lectures. Now, while Melody was posted in the training center, he did exceedingly well. Possibly he has he can speak well, his lordship has seen. So therefore, in the training center, he imparted very nicely. He educated those staffs and had they did well. So therefore, Melody, he got 95 marks there. There is no doubt. The question would be, Melody, your lordship will, these are the routine exercises every year done. Now, it doesn't mean that in a given year you have got 95 and the relevant year you will not get lesser. He has shown a judgment. He was leopard, he wanted to be leopard all
No,
the time.
but for the year 2006-7,
Those are my lord, not
under
required.
leadership, he had 75%.
Yes,
2007-8, he had 75%. Suddenly for 10-11, it is 37.5.
yes. Now,
Then-
those are the instances given.
No, because you see, then again it is 100-100.
Right,
No, but there is this, there is a sudden fall
right.
in for 10 and year,
Now,
for that relevant year.
now it happens. my
Could
lord,
be because of that posting.
because of the posting and where he is working. Now, in a IIM, my lord, while he was imparting, my lord, a training to the students, my lord, he did exceedingly well. Now, it doesn't mean that when he comes again to the branch, being an incumbent, he did not do well because he could not do good marketing. Now, those are the factors, my lord.
These are, you have stated all this in your affidavit.
Yes, I very elaborately have stated. I
You
can read.
take me through this, just indicate the
Well,
paragraphs.
my lord, I'll take your lordship to page 140.
Page
140.
140.
My lord.
Yes.
I'm seeing, my lord, whether it should start from. Well,
I think it should be from some,
let us read from page 137,
yes, para 5.
para 5 onwards.
No, you don't have to read. I just wanted it.
Right.
You've already made your submissions. I just wanted to see if it is,
Find elaborately all these things, page 5, 6, then 8,
9, 10.
then paragraph 12, I think I have dealt specifically in this subject. Paragraph
You can read 12.
Paragraph 12, yes. That in regard to paragraph 14 of the writ petition, your deponent states that in compliance of the order dated so and so passed by this honorable court, representation dated so and so, for upgradation petition at APR marked for the year 2010-11 was only considered and disposed of by the appropriate authority. And the same was communicated to the petitioner by quoting the remarks, I have seen past performance and performance in the branch. Maybe in training college he has done good, but as branch head his performance is not so good. And marks
But
allotted.
when was this communicated? Because one of his ground is also that the ACR for 10-11 was not communicated at the relevant time, but only after 2014.
Right, that your lordship will
That
find-
is after his promotion.
As your lordship has seen, this honorable court passed an order which your lordship will find at page 45.
Yes,
There were direction given,
for giving the ACR.
right? And
So
that we have-
that's an admitted fact.
we have furnished to them.
No, but prior to that you have not.
Yes, your lordship is right, very right.
So then what happens?
And then, my lord, we have furnished.
No, non-furnishing for that particular year, which is now admitted. What happens? Then logically, what follows from there? Because he has one decision of the apex court which
Yes.
says that then that year has to be ignored.
Now, supposing, my lord, if your lordship ignore also, at this point of time, he is retired.
Maybe,
Now, the
but
question
the
of
benefits.
the benefit, the question is promotion cannot come at this stage. Because he did not
Uh,
assume the
uh,
charge in the.
There is
property.
some decision which he had relied. The
I
two-
have also decision.
No,
that-
no, where, how it is to be done is given, perhaps you have to see that.
That.
No, because why I'm interjecting here is because looks like there is an apex court decision on this point, right? You perhaps have looked into it. The decision on this point specifically, I think this number 3 not communicated. No. Number 5. Yes. This is Jiban Lata Devi. Not communicated. And there is another one. There are 2. No,
Look,
there is
yes.
only one. Yes.
My lord, your
Have you
lordship-
gone through these?
No, I haven't gone.
So then you have a look at these two,
My
Mr.
lordship,
Datta.
Can I propose one thing, my lord? Let me go through it minutely. And because I have a decision also because. the
Very well,
person-
I can have it on 2nd or no, 2nd to Sundays again.
My lord,
So we can have it on next Monday.
just I will see, my lord, possibly I'll be out of station for
Oh.
a few days.
Because you see, Mr. Datta,
6th, can you lordship?
because there can be 2 ways. I mean, you see, if this court finds, admittedly, this has been, that's an admitted position. Now, suppose this issue has been dealt by the apex court, and then that issue will squarely cover this
I will see
point.
whether.
Correct,
recurring
correct.
with the
Now,
facts.
if that is so, then perhaps this court need not take the elaborate
Yes.
exercise and find out whether all that.
Right.
Correct. So in that situation, we can follow what has been done in Vijit Ghosh.
There is a latest decision.
So
also.
you look into this aspect since you are giving the reply.
Mm.
So I shall keep this matter part heard and I will post it on.
And if it is not inconvenient to your lord.
You have a Mr. Roy also has to come. So you
Yes.
suggest a date
Convenient. 6th, my lord. If he has-
6 November.
Yes.
6 November at Pariba. All right, we'll have it posted, Matok Kabak. Mr. Roy, you've already heard him. So let us see if Jiban Lata Devi's decision that you're relying because of the admitted position that for that year. So if that is so, then maybe we can also whatever has been done in the case of Vijit Ghosh can be also extended in your case. But let Mr. Datta be satisfied with whether it shall cover or not. Otherwise, of course, we'll have to go into the merit of the entire case.
Because there is a latest decision.
You have it.
In the year 2020.
You bring it.
Right.
Yeah, you bring it. To Likhil Vasu. Heard Mr. Debashish Roy, petitioner in person. Also heard Mr. S. Datta, Learned Senior Counsel, assisted by Mr. S. Datta, Learned Respondent, PNB Authorities. Mr. Roy concluded his arguments. However, Mr. S. Datta, Learned so and so, during the course of his reply arguments, sought a short of accommodation to go through the 2 decisions of the apex court, i.e. R.K. Jivanlata Devi and Avijit Ghosh Dastidar, relied by Mr. Roy, comma, full stop. Prayer is allowed. Relist on 6 so and so for further hearing. Matter be treated as part heard.
Obligation.
Typing item number 2.
Parisan, दिग्दार हुआ ना? Yes, Mr. Barpujari.
Okay, please, your lord.
Yes, what is the update?
Update, my lord, if lordship may be pleased to peruse, my lord, the last order dated 14 to 25.
Some communication was,
yes.
and it was supposed to be considered in the next budget.
My lord, if
So
I
what
may-
happened?
Yes, my lord.
You
if
are
I may-
supposed to complete your instructions.
Yes, my lord, what has happened here, my lord?
Just 1 second, Pranav. Yes, please.
I have obtained the updated instructions, but prior to that, my lord, let me just read my lord earlier order that will clarify the issue, my
No,
lord.
but if you have received or you have not received the instructions,
My lord, I have received, my lord.
what does the instruction say?
Yes, my lord, what has happened here, my lord, on 11th of February 2025, the Soil Conservation Department has written a letter to the Finance Budget Department, which is responsible for making budget provision, any budget provision, to the effect, my lord, that that particular amount of 170 lakhs, 170 lakhs has to be earmarked. My lord, they have only given an estimate. Accordingly, my lord, on the strength of that letter, my lord, the estimate has been recorded in the portal. Nowadays, my lord, it has to be done online. There is a FinAssam portal, my lord, it has to be done online. Now, my lord, after doing so, my lord, the Soil Conservation Department is required to send a formal FOC proposal, which we call it, my lord, fixation of ceiling. Unless and until that proposal is routed through the online FinAssam portal, Finance Department cannot, my lord, release the, my lord, amount. And that is number one. Number two, my
So
lord,
now what is the order that you are seeking
my
today?
lord, that proposal is not forthcoming from the Soil Conservation Department.
Where, who is appearing for the soil conservation? Who is appearing? Are they our party respondent here?
Yes.
They are.
They are the prime respondent.
Who is appearing for the department? Mr. Barpujari, since morning this is going on. Either one of the panel council of any one of the department is not there when the matters are being called. This is what has been going on since morning.
I have received.
How do we proceed? We cannot be keeping all the matters time being. I mean, this is not just one matter. Otherwise, I would not unnecessarily waste the judicial time by lecturing on this. But this is what is going on since morning. This court is not being able to progress with the list. Mr. Bora has been here since morning. Yes or no? In fact, I have asked him, requested him to inform the AG as regards what is going on. If you require more panel advocates, you induct more panel advocates. There are so many bright, competent young advocates in the court. Induct few of them. But matters are called department, the councils are not appearing. Now, for example, in your case, in order to pass an effective order, the standing council, soil conservator has to be here. Now, the moment I do it for time being, Mr. Councils he's been here since 10:30. Because at that time you were not there. Now you have come, now he is not there. So it is causing prejudice to the councils here. And so many other lawyers are as well waiting in the court today. I have a huge board. Yes, call for him. You ask him to come. Whoever, Mr. Rabha is there. Ask him because this order has to be passed in his presence. But Mr. Barpujari, please kindly get it to the notice of the Advocate General.
My lord.
It is obstructing the administration of justice.
It is shown in the cause list event, my lord.
That's what I am saying, Mr. Rabha. Sorry, Mr. Barpujari, the names are shown. The problem is that they are not physically before the court when the matters are called. Yes, next matter, time being corridor. Or otherwise, just 1 second. Item number
This is two, my lord.
heard Mr.
Aye, Hassan.
I.
Hassan.
Hassan, learned counsel appearing for the petitioner, also heard Mr. R. Barpujari, learned standing counsel, finance. Stop. It appears that in terms of the last earlier order, I-14 to 2025, Mr. R. Barpujari, learned standing counsel, has received his instruction, whereunder it appears that the proposal in question is unable to being progressed due to
The soil conservation department has not sent any formal FOC proposal.
since the Department of Soil Conservation has not sent the requisite for
FOC proposal, FOC,
FOC,
fixation of ceiling. FOC proposal
FOC proposal
through the Fin Assam portal.
through the
Fin Assam,
field Assam,
FIN, my lord, and for Nagar.
just Mr.
Yes, yes,
Barpujari,
yes.
just write it down.
Okay.
So and so portal. Stop.
Unless that is sent, my lord, the finance.
He
department-
further submits that unless the said details is sent in the requisite form,
My lord.
the proposal cannot be
My lord, the
considered.
Yes, finance department cannot consider the budget estimate.
Cannot consider the
Budget estimate.
the budget estimate
Estimate.
in
Yes.
question.
Yes, my lord.
Stop. It appears that despite the name of Mr.
Yes, sir.
S.R. Rabha, learned standing counsel, Soil Conservation Department, Assam, being reflected in the cause list. However, there is no representation on behalf of the Soil Conservation Department, Assam on call. Stop. In the absence of so-and-so, this court is unable to determine as to why the so-and-so form has not been updated in the portal till date and the up-to-date status as regards the same. Relist this matter when, Mr. Hassan?
Next week, Lordship.
The date, on such and such date, let a copy of this order be also intimated to Mr. SR to the Soil Conservation Department, Assam, so as to ensure that on the next date fixed, there is representation on behalf of the said department. Relist accordingly. Yes, next.
Item number 9.
Finally, there is the order dated, my lord, 29, my lord,
This is item 9.
item 9.
Yes. Instructions. Go get hold of Mr. Barpujari. He may not have gone too far. Mr. Barpujari, finance. But today he may not be entrusted with this brief because he looks surprised.
You may kindly peruse the instructions. Mr.
So instructions not forthcoming from PNRD.
PNRD, because my lord, the database, the petitioner is the employee of. the
PNRD?
department. They will have to furnish the.
Yes,
requisite
PNRD.
details.
No, but you are, I'm sorry, I forgot your name. AK. Mr. Ghosh, You see, whatever is to be done needs to be done. Those matters are going on, right? So every time one department says the other department is not cooperating, but at the end of the day, you all are the departments of the same government, same state, correct? So that cooperation must be there because we cannot be passing orders on every occasion, directing the other department to do what is to be done, required to be done. You don't need any orders for all this. And in that situation, this 226 court will become nothing but some executing court. So I'm going to record this submission and you do whatever is to be done. Yes, Mr. Datta.
Yes, my lord.
Sorry, Datta.
Yes.
Yes. Heard Mr. K.R. Padgiri, Learned Counsel for the petitioner. Also heard Mr. R. Barpujari, Learned Counsel, appearing for finance. You're appearing for finance.
Finance, my lord.
Learned Standing Counsel, Finance. Huh? Stop. And Mr. S. Datta, Learned Standing Counsel, PNRD. Stop. In terms of the last court's order, I 10/9/2025, Mr. R. Barpujari, Learned so and so, places the instruction dated 27/10/2025 received by his office from the Undersecretary to the Government of Assam Finance EC1 Department, whereunder it is informed that the PNRD, being the administrative department, was requested to furnish necessary instructions stroke parawise reply. And since the same was not forthcoming, it was followed by another reminder on 24/10/2025. However, till date, no instructions have been received from the said department. It appears that the instructions required in order to effectively decide the list in hand is essentially from the PNRD department. Mr. S. Datta, Learned Standing Counsel, PNRD, assures that the requisite return shall be filed within a period of 3 weeks from today. In view of the aforesaid assurance, relist after 3 weeks on a date to be fixed by the registry, it is needless to be clarified that upon the return being submitted on behalf of the PNRD, the finance shall be at liberty to file a reply as well, if so advised.
In this matter,
Yes, put Mr. Ibora's name as well. Yes.
I'm obliged.
that being item number 10.
Yes, Mr. Chetri, you had to wait for quite long.
I'm sorry, Lordship.
Yes, Mr. Gogoi.
Lordship, on the last occasion, you asked to take instruction on this letter.
Apologies accepted only this time, not always.
I'm sorry, Lordship, I was talking
I know you all are busy counsels, but please have someone at least present in the court.
the issue is that.
No problems. Yes.
That letter at annexure, page 27, annexure 8, your Lordship. That letter, which they said that as
No, you are you
Applied-
submitted.
they applied in time, saying that this letter was given within the time frame of for a completion appointment, Lordship. That page 27, annexure 8.
Just one second. I'm not being able to connect to the case. You're straight away taking me to some page 27. Mr. Chetri, the detail order is at the order of this court 17/9.
17.9.
So they had rejected the claim of the, this is compassionate,
Yes.
a compassionate claim filed by the mother by referring to another application.
Another application which was in 2019.
But whereas they have not considered the application of 5/10/2015.
2015.
Yes.
Yes.
This 15 application, I have verified with the department, they have not received any application because as per them, if they receive any application, they have to make a receipt mark on it, your lordship. There is no receipt mark. There is,
Then you put an
they
affidavit.
put an affidavit. and
Well,
further,
the
that-
petitioner has to respond.
Yeah.
That lordship will find at page 28. It was received by them that in the top. It was
20?
28 in the vernacular lordship.
Yes,
There's
that.
no stamp on the lordship.
No, they received it.
Correct.
Their
There
office.
has to be a stamp, receipt
See,
date has to be there.
once again, I cannot understand if both councils talk together, speak together. Mr. Chedri, this 13, 11, 15, that is the stamp or which one?
No, 5/10/2015 lordship.
No,
Page 28.
page 28 is that there is a vernacular letter dated
Yes, yes.
3/11/15.
No, it is 5/10 lordship.
5/10.
28.
Just indicate here, Mr. Chetri, in the court's file, you can just circle that stamp, what you are saying is there. Come on. That'll be different. Just put a circle.
Just underlining it.
Just show it to Mr. Gogoi also.
I've seen in lordship.
You've seen
Yes,
it?
Yes. They have,
Come. Print.
that's a date they have underlined. There's no seal, your lordship. This is not a seal.
All right, then you put it in your affidavit, what you want to
And
say.
if I may.
At a short, on a short date.
Oh, my lord.
This matter is pending since long and it's a compassionate appointment matter.
And
Keeping this matter further pending would only, make the petition further in a vulnerable position. So you have it filed next week itself.
very well, lord.
Nothing more than that. And Mr. Chetri, let him file. I'm going to fix it on Friday.
Friday, your lordship.
Friday. After that, if you want, you can file a short reply. Heard Mr. B. Chetri, learned counsel for the petitioner. Also heard Mr. G. Gogoi, learned. Sorry. R. Gogoi, learned standing counsel, PN, PHE department, and Mr. D. Bora, learned government advocate for the state. Stop. Mr. Gogoi so-and-so submits that in terms of the earlier order dated 17/9/2025, his office has received the instruction that the concerned department has not received any application dated 5/10/15 allegedly stated to have been filed by the mother of the petitioner. Stop. Mr. B. Chetri, learned so-and-so, disputes the said position by referring to the
Endorsement, my lord.
to the endorsement made in the said application dated 5/10/15, appearing at page 28 of the brief. In view of the above, let the instructions be placed on record by way of an affidavit, relist on such and such date. It is needless to be clarified that the affidavit as directed shall be positively filed by the next date of listing.
I just opened 5K.
Yes.
Can you see the last order, my lord? Order dated 21/7/25, my lord.
21/7.
Lordship, Lordship, today morning we have received the instructions regarding appointment of all the petitioners.
Already appointed,
Not all.
few of them. Give a copy to the other side as well. You have another copy, no? So how many petitioners are there?
10 petitioners, earlier
petitioners.
one.
Out of 10 petitioners, how many have been appointed?
Lordship, petitioner number 2, 3, 5, 6, 8, and 10. Total
Two?
6 petitioners.
Petitioner number 2,
3,
2, 3,
5,
5,
6,
6,
8,
8,
10.
10. And who are left?
7
One.
and
One.
1 is there. 1,
Lordship, withheld clear
4,
in concerning.
huh?
In concerning petitioner number 1,
Huh.
withheld clear. And
Where do you find that? I don't find it here. What is clear that you are submitting is? Oh, that serial number 1 is the petitioner, right?
yes, Lordship.
Withheld clear. So then he will get his appointment, I think. 1,
Yes.
because it seems withheld clear.
Yes.
So I
Yes.
think it's in the process.
Yes,
Then what about 4? Result declared, offer appointment is in process. As regards 6, already offer appointment. 7, case returned due to re-verification. Verification by the vendor during the time is under progress. Verification is under process. 9, verification under process. 10,
Already appointed.
he has already been appointed.
appointed.
But in this regard, there is an order, my lord, of this honorable court. In similar circumstances, some petitioner was appointed, some are pending, my lord.
Kamal,
In the under 3 months' time to complete the process, my lord.
and is disposed of.
Yes.
So I can similarly dispose this matter.
Yes.
The same advertisement,
Same advertisement.
27/10/22.
Yes, yes, yes.
Recruitment of Constable GD in the Central Armed Forces,
Same, my lord.
same thing.
Same.
So all this will be the same.
Same, my lord.
Result declaration date also same.
Same, my lord.
Heard Mr. Huh?
Isar Ahmed.
HR Ahmed, Learned Counsel appearing for the petitioner, also heard MS.
J. Gayan.
J. Gayang, led at CGC. Stop. By way of this petition, under Article 226 of the Constitution of India, the petitioner is canvassing the non-declaration of their results in response to the advertisement dated 27/10/2022 for the recruitment. Paragraph 2 side libo. That should be good. Huh? Paragraph 3 paragraph 4. Today, when the matter was called, the learned CGC, on instruction, submitted that the results of petitioner number 2, 3, 5, 6, 8, and 10 has been 10 were verified, and after verification, they have been appointed. Stop. The result in respect of 1 appears to be, in respect of petition number 1, appears to be as regards petitioner number 1, it appears that the earlier kept withheld after verification has been withheld. Has been cleared. Sorry, has been cleared. Stop. It further as regards petitioner number 4, it appears that after verification, the results have been declared and the offer appointment is in process by the headquarter. Further, as regards respondent number 7 and 9, it appears that the verification process is under process, that the verification is under process and the same is likely to be completed at the earliest. Considering 852 Yanis again same order, huh? Disposed of. এখন চাই ল'ব যদি ভৰাই দিব পাৰে এখন আমি ভৰাই দিম আৰু কেপচন ৰেকৰ্ড কৰি দিব এইটো yes
Item 14.
In this case, my lord, no affidavit has been filed by the respondent.
yes but where is the respondent, where is Mr. R. Islam?
It is the private respondent, my lord.
You are appearing.
I am appealing for respondent number 8, 9, 10, 11 and 12.
A state affidavit also not filed.
Not filed, my lord.
State was directed on the last
Yes,
occasion.
Lordship, but we are yet to receive the proper instruction.
So how much time?
Lordship, I am just praying for 3 weeks' time, Lordship.
Heard Mr. K.R. Padgiri, learned counsel for the petitioner. Also heard Mr. You are there or not?
And the
D.
Bora.
D. Bora for private respondent.
private,
Respondent number?
but not the implemented.
Huh?
Rafiqul Islam for newly.
No, which? Give me the arrangement of the respondent numbers 8, 9, 10, 11 and 12. And MS M. Bhattacharjee, learned additional senior
State
government
advocate.
advocate for the state respondent. Who is now unrepresented? The newly implemented.
Newly or Rafiqul Islam, my lord.
None appears. You are there. Then say, come here. Why are you hiding in the corner? Yes. What is your name?
My name is T. Talukdar.
T. Talukdar. MS T. Talukdar, Learned Council, is present for
We have respond 13 to 19.
13 to 19. The newly ones,
My lord.
the new implemented ones, huh? Stop. So all is all there's a joint prayer from all the respondents to file the affidavit. Yes or no, ma'am? You're going to file an affidavit or not? Your senior have not given you instructions. M. Bhattacharjee, Learned State Council, seeks for 3 weeks' time to file return in the matter. Prayer is allowed. Relist after 3 weeks on a date to be fixed by the registry. It is needless to be clarified that by the next date of listing, all the remaining respondents, including the state, shall file their return positively.
Item 15.
In item 15, Lordship, they have given steps yesterday only,
Oh,
after March.
okay. Heard Mr.
M. Rana.
M. Rana, Learned Counsel for the petitioner, also heard M. Bhattacharjee, Learned State Council. M. Bhattacharjee, Learned so and so draws the attention of the court that despite notice being issued way back on 3/3/2025, extra copies have been served upon the office of the state only on
28/10.
28/10, 2025. She accordingly seeks 3 weeks. No, she ito nokobo dise hai. In view of the delay in taking steps against the state respondents, relist after 3 weeks on a date to be fixed by the registry.
16.
Yes, please.
In this case, my lord, the state has to file affidavits.
I was wondering why he's looking at you. Now I know. Yes, return. Are you going to file or I'm going to foreclose the return?
I am appealing for 2 and 4, lordship. Today I have filed Wakalat Nama, to which time may kindly be given.
You are for the private respondent. Yes, state.
Earlier,
I think this is a matter of the development authority only, so they are.
You are appearing for the development authority. Heard Mr.
Jiuddin.
Jiuddin, learned counsel appearing for the petitioner. Also heard Mr.
Yes, Law.
P.S. Lawkor, learned counsel appearing for the
2 and 4.
respondent numbers 2 and 4, and MSM so and so, learned counsel appearing for the state respondents. In view of the appearance of Mr. Lawkor, service in respect of respondent number 2 and 4 stands complete. As per the relist after 3 weeks on a date to be fixed by the registry to enable the respondents complete the return.
All right.
Item 80.
दिखदार पाइছে নি?
Lordship,
Yes.
we are still awaiting instruction, Lordship.
You have?
You are awaiting instruction.
Awaiting.
Lordship.
All right.
In the last occasions, you have been awaiting instruction, my lord. I put it-
But nonetheless, it's a 25 matter.
I know.
So we'll give them another chance. You are in a better footing than the earlier matters. Those were matters of 23, 24. So we that doesn't mean we will allow them merrily go on taking time. We'll end it. Don't worry. Esprit, their name to read it.
Ki ba pangalan?
So and so for the petitioner, R.R. Gogoi, Standing Council Forest Department, and Esprit form by R.R. Gogoi, so and so, relist after 3 weeks on a date to be fixed by the registry to enable the so and so department to submit return in the matter. It is needless to be clarified that the return shall be positively filed by the next date of listing.
Item 19.
Item 19, my lord, I am praying for 2 weeks time to file affidavit, my lord.
Ms. Devi?
Yes.
R. Devi for K. Devi for the petitioner and
NJ Khatun.
N.J. Khatonia for the which department?
Secondary education.
Secondary Education Department, as paid by so and so. How much time?
2 weeks, my lord.
2 weeks. And Mr. Chutia, you're also there?
Yes, but
For?
board.
For the board, their appearance to the deliver. TC Chutia for the respondent board, na? The R5. R5, right? R5. You also are going to file?
My lord, we will file, my lord.
R5.
Yes, sir.
5 and
So,
4 and
kind of board.
4 and 5, my lord.
4 and 5. 3 weeks.
Yes.
Yes.
Item 20.
Okay, this is with regard to also non-finalizing.
Why today all the matters listed before this court, nowhere the returns have been filed?
Lordship, last occasion,
These matters I don't know, they are given under what column? Admission column. They should have been in the order column. When matters are posted in the admission column, we try and go into the merit, but seems like that stage has not arrived. Yes.
retired in 39/2023, yet his pension has not been finalized.
Yes, why are you taking so long, Mr.
In terms of last order.
Talukdar, na?
Yes, Lordship.
Yes, Mr.
In terms of
Talukdar.
last order, Lordship, I obtained instruction, Lordship. The Karbi Anglong Authority is yet to forward the pension proposal.
No,
Lordship.
no, but that's not any instruction. Why are
Lordship,
you?
I am for the accountant general. Lordship.
Yes, but why, you see, that cannot be the instruction because where is the Karbi Anglong Council? Where is KAC? Where is Miss Compry?
Lordship, my main grievance is against the AG because they have raised the objection, Lordship.
They may raise an objection. You cannot now say that they cannot raise an objection, Mr. Counsel. If they have raised an objection, then it is for the concerned department to
Yes.
clarify.
No, Lordship.
Where is KAC? Heard Mr. S.K. Das,
Yes.
learned counsel appearing for the petitioner. Also heard Mr. R.K. R.K. Talukdar, learned standing counsel, accountant general. Stop. It appears that in terms of the earlier order, i.e. 15/10/2025, Mr. Talukdar has obtained instruction as regards the up-to-date status of the pension proposal of the petitioner. Stop. As per the instruction received, it appears that
Lordship, pension proposal is yet to resubmit by the Karbi Anglong.
it appears that as regards the objection raised by the accountant general, comma, the concerned, just give me that now. The concerned K and the KAC counts. Are yet to receive the pension case are yet to, so কি বুলি লিখিছা? Comma, the executive engineer PWD R&B Mechanical Division DIFU Karbi Anglong Assam has not resubmitted the pension papers of the petitioner. Stop. For which the matter is not being able to progress at the end of the Accountant General's office. Stop. However, today when the matter is called, the learned counsel appearing for the KAC is not present in the court. That being so, the matter cannot progress in the absence of the learned standing counsel KAC. It is also noted, the name is reflected or not in the cause list? The name of the standing counsel KAC is also reflected in the cause list. Let this matter be re-notified on Tuesday, Mr. Da, on Tuesday so and so, with an intimation to the learned standing counsel, with an intimation to the KAC, Principal Secretary KAC through the registry, by the registry.
My only grievance is that resubmission was already done. It is phase 20.
Anyway, let them, they have given. Yes, Mr. Talukdar, you don't have to react to everything. Yes. You take
Okay.
this back and I think you put an affidavit if needed.
Okay.
21. Your Lordship, as per the order of the Honorable Court, I have submitted an application and the matter is under process, Your Lordship. So let it come after 2-3 weeks, Your Lordship.
Hmm?
Regarding payment of provisional pension and other retirement, I have submitted my application along with all required forms and documents as per the order of this Honorable Court, and the matter is under process, Your Lordship. So let it come after 2-3 weeks.
Why, then we can dispose it.
Let it be kept pending, Your Lordship. Let's see.
You want the sword to be hanging. You want a sword to be hanging.
Yes, Your Lordship.
Huh? Why?
Pending that they will comply, Your Lordship.
It is not so, Lordship. They have made a mistake, Lordship, not approaching the proper authority, Lordship.
Alright, as prayed for relist after 3 weeks on a date to be fixed by the registry. Much brilliant. Hold on, Sinu. Easy to come.
Item 22.
Please, Your Lordship. See, on the request of the senior government advocate, Mr. D. Nath, he requested me to pay for the court for some accommodation losses because the process of filing the affidavit is going on in both the, item 22 and the other one. 22, 23.
Hmm?
Item number 22 and 23.
Alright, you have a stay till then.
Yes, ma'am. The thing is that, mother, there are series of cases, my lord.
Very well, I'll ask them to list it along with.
Some cases has been listed today in court number 7, my lord. That case, 1st December, there has been fixed.
Alright.
I give the case number.
Okay, heard Mr. NNB Chaudhary, learned counsel for the petitioner. Petitioners also heard Mr. CK S. Barua, Barua, learned
Yes.
government advocate for the state. Mr. So-and-so seeks further, how much time?
3 weeks time, Lordship.
3 weeks time to complete the return in the matter. Prayer is not opposed. Relist on, yes, the date
My lord, on 1st December.
on 1/12/2025 along with so-and-so. Please give the list.
2025.
There is interim order.
Interim, if any, shall continue to the next date of listing. Sorry, I did see and I forgot. Yes.
Oh,
Same order for 23 will also do.
23.
All right. In 23, Mr. NNB Chaudhary is not there.
My name may be recorded. Lord.
No, that's right. I just saw.
Yes.
That is why
Yes.
Mr. Chaudhary didn't say about 23. On a lighter note, Mr. Chaudhary. Yes, 23 teketor naam diba. MP na, your name is
Yes,
MP
Lord.
Chaudhary.
Highly aware.
24.
Yes, Mr. Das.
Instruction adoption.
Yes.
Regarding issuance of the certificate.
It seems like today all the matters where instructions are forthcoming are being only listed before this court.
Yes.
Huh?
Lordship, 3 weeks time may be granted to file affidavit.
As prayed for by MS.
M does on behalf.
And so 3 weeks ko diba? Yes. Yes.
In this matter also, my lord,
Instruction. Yes.
affidavit in opposition have to file, my lord.
Yes.
But my lord, I have limited prayer, my lord. My lord, petitioner's grievance is that there is a disciplinary proceeding going on, and in the meantime, the petitioner retired on 31st of December 22. Till that, they have not concluded. That was the grievance, my lord. On the last occasion, Council for the Animal Husbandry Department has submitted an instruction, that is flag A, my lord, whereby it's stated that the disciplinary proceeding has completed, but some formalities remain there, my lord. May I pray for dispose of the matter, directing the respondent to communicate about the findings of the disciplinary proceeding, my lord. In this regard, petitioner has submitted a representation that was not responded. Because of that, the petitioner came before your lordship.
But yours, your grievance in the present writ was the continued suspension.
No, my lord.
No. Where is your prayer? No, I can dispose it, but I'm just
Yes,
trying to
yes.
see if
Yes,
that would serve the purpose.
I have submitted the representation, my lord. Representation is at page, my lord.
Oh, yes, this is your
37,
prayer. And where is your representation?
At page 37.
It will be
The last but second paragraph, I have.
Okay. Heard Mr. K. Bhattacharya. Sorry.
M. Soikia, my lord.
M. Saikya, learned counsel appearing for the petitioner. Also heard Mr.
DJ Bora Lordship on behalf of J.K. Goswami.
DJ Bora.
Boro.
Boro, learned counsel appearing on behalf of Mr. J.K. Goswami, learned standing counsel for the respondent numbers 1, 2, and 4, and Mr. C.K.S. Barua, learned government advocate for the respondent number 3. By way of this petition under Article 226 of the Constitution of India, the following the writ petitioner seeks the following prayers. Page 14. By way of this petition, and so and so, is seeking for a direction to the respondents to furnish information regarding status of the departmental proceeding initiated against the petitioner and directed to conclude and for directing thereafter to conclude the same within a short span of time and for communication thereof as regards the outcome of the said departmental proceeding. Stop. Mr. So-and-so learned counsel for the petitioner draws the attention of this court to the letter which was produced by the standing counsel so-and-so department on the last occasion, I-26/9/2025, which is available in the record as Annexure A, to indicate that the Deputy Secretary to the Government of Assam, Animal Husbandry and Veterinary Department, Dispur, has decided to impose the penalty of withdrawal of pension for the first year of retirement, recovering the same from his future pension in respect of the petitioner, and in order to impose such punishment, approval, and the proposal has been sent to APSC for the requisite approval. Stop. Though today the matter was posted for placing the up-to-date status of the, no, that's what Lekhiba. It is further, upon hearing the parties and considering the materials placed on record, it appears that the petitioner has filed a representation on 21/5/2025, which is enclosed as Annexure 13 to the writ petition, requesting for information on outcome of the departmental proceeding. It is apparent that the departmental proceeding has been concluded. However, the outcome of the said departmental proceeding is still not provided to the petitioner. That being so, I am of the considered view that this writ petition can be disposed of in the interest of justice by directing the respondents to conclude, to communicate, to consider the representation of the petitioner in accordance with law. Don't say consider representation. To direct the respondents to communicate the proceeding of the departmental proceeding in accordance with law within a period of 3 weeks from the date of receipt of certified copy of the order. Yes, Mr. Barwa?
To conclude that, I think 3 weeks.
I said communicate. Departmental proceeding is already is already done, and they are recommended that the proposed punishment also to APSC. Now they are supposed to communicate, but he has not received. That is his prayer.
Yes, sir.
So that can be given to him.
Yes.
Yes. Disposed of.
26 and 27.
Replace Cordia.
May I please? My lord, in this matter, my lord, an amount of rupees 4,19,725
Returns.
sought to be recovered, my lord.
Returns.
Instruction awaited.
Await instruction, relist after 2 weeks or a date to be fixed by the registrar.
My lord, the only thing is that I am getting pension, my lord.
It is needless to be clarified that on the next date of listing, if at that date after 2 weeks, if the return is not filed, the erring respondent shall be personally present in the court. Since the matter pertains to non-payment of pension.
Yeah, already recovery, my lord, not recovery.
Yes, next.
Recovery from the pension.
Okay, next.
19 November. Subject is item number 41.
May I please, Lordship? Matter pertains to retirement benefit of Anganwadi worker, Lordship. Kindly peruse the order dated 24/9/2025, Lordship. Paragraph number 6, Lordship.
May it please, your Lordship.
Yes.
Lordship, in this case, thing is that Lordship, the question is, the issue is in regard to
No,
payment.
but paragraph 6 says accordingly the court is inclined to provide that on the next date of listing, if the terminal benefit of the petitioner is not released, the respond number 2 is put to notice to show cause as to why delay has occurred for non-disbursement of the terminal benefit of the petitioner, and also to show cause as to why an appropriate order should not be passed by the court directing interest at 9% should not be imposed on the state for non-payment of retirement dues of the petitioner despite budget issuance.
Understand.
Yes, number 1, let the first question be first answered. Has the terminal benefit of the petitioner been released?
Lordship, today, Lordship.
Yes or no?
Lordship, today I cannot answer that. Lordship.
No, but that is why the matter was posted today. Otherwise, you have this person present in the court on the next date. I'm fixing it on Friday. Let him be personally present because this is a very strong order passed on 24 September.
This order already been
2025.
communicated on 26th
Correct,
May.
Mr. Council, but today why the matter has been posted?
Basically, whether
Yes,
that's fine, Lordship. I
and
should have
this-
to get the instruction from
and
the
you
party.
see, if that instruction is not there,
Yes, sir.
then the outcome is also given in paragraph 6. Yes or no, Mr.
Yes,
Council?
Lordship, yes.
You're an officer of the court.
Yes, 100%. Lordship.
Yes, so then what is left for this court to do? Tell me, Mr. Barwa.
Yeah, technically, Lordship, he should have been present.
Correct. He should have been present or someone should have been there on his behalf.
Or some instruction, Lordship. that
Correct.
we have put.
Correct. Nothing is there. Neither the information whether the terminal.
And from our side, we have all well communicated on 26th.
Correct. And neither the information that the terminal benefit is released or not is not available.
It's not
with you.
available with me right now.
Then what is to be done? When did you communicate?
26/9. The date.
Right,
the date
please
of
take
my
down.
letter.
Heard Mr.
MS Mondal.
MS Mondal, learned counsel for the petitioner. Also heard Mr. C.K.S. Barwa, learned government advocate for the respondent numbers 1 and 2. And anybody appearing? You are Bora. MS F. Bora. B. Bora. Learned standing counsel for respondent numbers 3, 4 and 5.
3 and 4, madam.
3 and 4. Standing counsel of what department?
On behalf of Ms. Bhuya.
Learned counsel appearing on behalf of MSB Bhuya, learned senior counsel appearing on behalf of
Here. 3 and 4.
3 and 4. 3 and 4, no, not 5.
5 I am appearing. 1, 2 and 5.
ठीक है.
CDP.
It appears that the following order was passed on the last occasion, i.e. 24/9/2025, which reads as hereunder. Relevant portion of which reads as hereunder. Paragraph 3, 4, 5, 6, 7, 8, 9 Didiba. Reading of the aforesaid paragraph, it is apparent that by way of the aforesaid order, this court directed that if on the next date of listing, i.e. today, the terminal benefit of the petitioner is not released, comma, the respondent number 2 within brackets is put to notice to show cause as to why delay has occurred for non-disbursement of the terminal benefit of the petitioner, and also to show cause as to why an appropriate order should not be passed by the court directing interest at 9% should not be imposed on the state for non-payment of retiral dues of the petitioner, despite budgetary allocation being available to the Director, Women and Child Development Department. Stop. It further appears that in terms of the direction, in terms of the aforesaid direction, and as per the said order, comma, the learned government advocate on
26/9.
26/9/2025 downloaded the copy of the
And sent.
or a copy of the efforts of the said order and
Sent.
communicated the same to the respondent number 2. Stop. It appears that despite the knowledge of the said order, comma, today, no instruction as regards the query posed by this court on the last occasion, i.e. whether the terminal benefit of the petitioner has been released or not, comma, is available with the government counsel. Stop. It further appears that despite the respondent number 2 having been put on notice, neither the respondent number 2 is present before this court either through any engaged counsel or in person, nor any information whatsoever. As regards paragraph 6 extracted above, is been communicated to the government council concerned. It appears that the respondent number 2 is treating the orders of this court in a very casual manner, which is not acceptable to this court. The orders of the Constitution Court cannot be treated in this manner. Let respondent number 2 be personally present before this court on such and such date. Let the order of this court be communicated to the respondent number 2 through the registry of this court. Give a date. It is a 7th, that is Wednesday. And that is too long.
5th of November.
5th November.
What's that?
Okay, 7th. Let it not be on the 7th. You make it on 7 or piece or working. Good. And Miss Bhuya, you want your name? No, why you nodded your head, not for anything else? No. I am not saying that. All right. No, that I have already recorded, but since you have come, so I thought of asking. No problem. Yes.
Your Lordship kindly peruses the last order, the order dated 17/9/2025. Your Lordship will see that the notice was issued on the last occasion.
Lordship, we have prepared the affidavit and sent
All right.
for waiting a week's time.
Okay. As prayed for by Mr. B.K. B. Chaudhary, Learned Counsel, appearing for Standing Counsel.
Yes.
Learned Standing Counsel, so and so Department Redeemer, relist after 3 weeks on a date to be fixed by the registry to enable the said department complete return in the matter. Interim order, if any, shall continue till the next date of listing.
28.
A.K. Barua for the petitioner, Didiba. Enhancement.
For the last order, we were asking steps with the respondent 2, 4 and 1. However, Lordship, we could not trace the address of the respondents.
You want more time?
Yes, Your Lordship.
As prayed for by MS.
R.M. Barua, Your Lordship. R.M. Barua.
M. Barua, Learned Counsel, appearing for the appellant, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner do the needful in order to effectuate the notice on the respondent number
2, 4 and 1.
2, 4 and 1. Please give your names. Tell about number, Didiba. Against the respondents.
Wait, please, Lordship.
Yes.
There is some lapse on my part, Lordship. Notice on respondent.
You want some time for taking it up? Mr.
M. Talukdar. M. Talukdar.
Mr. M. Talukdar, Learned Counsel for the appellant, with profuse apologies, seeks further 2 weeks, 3 weeks. How much time you want?
1 week's time.
Further 1 week time to take
Fresh
steps as directed earlier, which for an inadvertent omission, which inadvertently was omitted to be taken earlier. Which was prayer allowed, released after so and so on a date to be fixed. Fresh steps or hetu koi diya.
Item 30.
Delay of how many days?
Your Lordship, 1646. 1646.
1646.
Yes, Your Lordship.
First time? Or
No, Your
notice has been
Lordship,
issued?
Notice was issued.
There's objection.
They have filed objection.
Yes.
So, Your Lordship.
Yes, what are the reasons? What this is for what? For filing what?
Appeal, MSc appeal, Your Lordship.
MAC appeal.
Yes, Your Lordship.
How the specified period is 90 days?
Yes, 90 days.
And 16, how much? What was the delay? You said 1646.
1646.
Yes, where is the ground?
Your Lordship, it is from paragraph 3, 2, 3, 4.
No, no, read. What is the ground? This
Your
is
Lord-
not a delay. This court can condone mechanically. 1646 is quite a lot, and they are seriously objecting. Correct?
Respondent. Is respondent could not.
Huh? Please come forward, ma'am. You have a copy of the affidavit that you have filed?
No, Lordship, I'm appearing on behalf of the respondent number 3.
Correct.
The engaged respondent could not have appeared today.
Or the engaged affidavit, engaged respondent is not there. If extra copy affidavit or deduction ticket. Let us see if we feel that your presence of the engaged counsel is required. I shall adjourn. Otherwise, let me see whether they have made out a ground for condemnation or not first. Yes.
Your Lordship, first of all, the applicants are the widow, 2 minor children, and old widowed mother of the deceased. And the only earning male member, that is the deceased, he died in that particular accident. So this is the position in the family.
So, 1 second. Who died?
One Motleb Ali died.
He is the husband.
He is the husband of applicant number 1
Okay.
and father of applicant number 2 and 3, who are minor. And
So now
son of-
this is so the husband died.
Yes.
And the wife filed this appeal.
Wife along with 2 children and widowed mother of the deceased.
But earlier, this is a MAC appeal.
Yes.
So wife had already filed a claim. Earlier, she had filed the claim.
Yes, there
So
are
she was aware.
4 claimants.
Correct. So she's one of the claimant.
Yes, yes, your Lordship.
So now she became your ground of delay is that in the meantime applicant number 1 became busy in upbringing of her 2 minor children, and as such it escaped from the mind of the appellant number 1 to collect the information about the status of the case. However, on so and so, the mother-in-law sustained fracture injury of right so and so and became totally handicapped, and there was no one to provide her any medical treatment. Accordingly, on so and so again returned back to her matrimonial house, and on the same day she accompanied.
Your Lordship,
What is all this?
Your Lordship, paragraph number 2.
All along she knew that this case
No,
is
Your
there.
Lordship, I have explained that in paragraph number 2. Respectively, earning member of the, as such, the claim case was looked after by her brother-in-law Nizamuddin Ahmed, who
Yes.
happens to be the husband of the younger sister of the deceased. Accordingly, it is only on 2 occasions the applicant number 1
So what
happens to
happened
visit.
to this brother-in-law?
I have also explained later on.
Anyway, as prayed for by MS.
Then I'm appearing for S. Begum.
So and so appearing on behalf of so and so, learned counsel appearing for the respondent.
Respondent number 3.
Respondent number 3, relist on such and such date. Are we on the ground that she's out of she has not come to court today
She got married, so she some personal difficulty.
due to personal difficulty. She is not been able to be present in the court today when the matter is called. And relist. When do you want it to be listed? Say because she is one. Probably she'll be on leave for some days.
4 weeks.
After 3 weeks.
Your Lordship, legal submission, Your Lordship.
What submission now?
No,
Yes.
in this
Next.
kind of cases, generally.
No, that you save your energy for the next date.
Oblige.
Yes.
31.
May you please, your Lordship, Meta may be taken after some time as the conducting counsel is in place.
A contempt matter. Who are the contemners? Office note. What is the office note saying? Fresh steps of service of notice not yet received. Yes, why are you not taking fresh steps?
Lordship, we have taken steps, but it's not.
So you have this information in your hand, then why are you seeking for posting the matter after some time? This much of information you are an officer of the court as well. You should be in a position to assist the court. You should not just mechanically seek time in all matters just because your senior asks.
No, Lordship.
Anyway, what is that? You have taken fresh steps or not?
Lordship, on we have taken on 6/1/2025, Lordship.
6/1/25.
2025.
But on 19/9/25, the office note says fresh steps not yet received by section. Respondent number 1. Okay, right. Heard MS. M. Bora, Learned Counsel appearing for the
Petitioner.
petitioner.
On behalf of Mr. S.K. Chaudhary.
Miss Counsel, I think fresh steps was directed to be taken on 4th of June 25. So have you taken after 4th June? I don't think you have taken, because you are saying you have taken on 6th January 25. That is your first step. After that, it came back with a note, refuse for no branch, RTS. Thereafter, there has been an order of this court. So I will say that you will take fresh steps as directed earlier. Okay? So you do whatever is to be done. You just see the court's file after the order is passed. You see the order dated 4/6/25 and the office note, which there is a pink flag. Come on. Have a look at it, after seeing this, if any changes to be made, I will immediately make in the order, but I am just saying it that as prayed for by MS, M. Bora, Learned Counsel for the petitioner, relist after 3 weeks to enable the Learned Counsel for the petitioner to take fresh steps as directed earlier by order dated 4/6/2025. Yes.
32.
My lord, matter of direction is, my lord, for the release of pension.
Sorry, Mr. Gohain.
My lord, direction is for release of pension as well as area salary, my lord. Nothing has been, my lord.
What about service?
Service, my lord, as per office dated 17/10/25, my lord, except respondent number 7, all are acknowledged, my lord.
7 not received. 7 anyone appearing? So I think we'll have to wait for 7. Who was appearing for the other contemners?
I am for 1, my lord.
Mr. The A. Gohai petitioner. Mr. Yes, Mr. Your name?
I am PK Bora, my lord.
PK Borua for respondent contender number
1, my lord.
1 and Mr.
Borua.
C. Borua for
Number 3, but
respondent number 3.
now that then officer already been
That's
transferred.
not right, but you have to continue appearing. He doesn't automatically get discharged. Yes. MS? RM Barwa. 2. Yes, Fukan. A Fukan. 4. Office note dated 17/10/2025 indicates that AD card in respect of 7 is still awaited. Relist after 3 weeks and a date to be fixed by the registry. In the meantime, the contemners, the respondent contemners who has entered appearance by engaging counsels pursuant to receipt of show cause notice of the instant contempt proceedings shall furnish the show cause as called for, as summoned for. Yes.
33. Same, my lord, 33.
They're also same.
Same.
R7.
Yes, my lord.
Okay. Same on. Obliged.
34.
Wait, please. This is a contempt case for non-compliance of an order, your lord.
AD card on sole respondent not returned back.
Service completed, your lordship.
Last occasion it says not.
As per Lauzima court's order, your lordship, and I think they have also entered appearance.
Is it?
In the cause list,
Item number?
34.
Has been completed. But where are they?
The names is also reflected in the cause list, I think.
We don't know. Some name is there, but this is the first time after service.
Yes.
Heard Mr.
MH Loskar.
M.S.
Loskar.
Loskar, na?
Lordship.
Learned counsel for the petitioner. It appears that though as per office note dated 9/9/2025, service in respect of the sole respondent has been completed, comma. However, there is no representation on the sole respondent on call. Mr. So-and-so further draws the attention of the court that that the names of two learned counsels, I. M.S. N. Bora and Mr. S. Dotto, is also reflected in the cost list as learned counsels appearing for the sole respondent. Be that as it may, relist on such and such date. By which date, it will be after 2 weeks, by which date the contender shall respond to the show cause notice received pursuant to the registration of the instant contempt case.
Obliged, Lordship.
Let the learned counsels be also intimated about the next date of listing through the registry of this court.
Obliged, Lordship.
35.
Yes.
In this case, service has been completed, Lordship. Maybe fit for admission.
Miss S. Chutia, my lord, she was supposed to bring the record, my lord, in this matter. I think the
record
record
was
will be required for the proper adjudication of this case. My lord, we'll fix this matter after 2 weeks, my lord. Today, I think because of she's indisposed, my lord. So, the next date, my lord, she will bring the records. That's be better because.
Right, Mohan.
Service has been completed, Lordship.
Heard Mr. D. Mohan,
Lordship.
learned counsel for the petitioner, and Mr. A. Fukan,
On
learned
behalf of S. Chutia.
standing counsel, learned counsel appearing on behalf of M.S. S. Chutia,
Chutia.
learned standing counsel for the respondent number 1, 2, and 3. Within bracket elementary education department. Stop. Mr. Mahanta draws the attention of the court that service in respect of the remaining respondent also, as per the office note,
628, 25, 625, let's see.
20.
I think 6 last of his.
No, R4.
R4.
R4 says neither AD nor unserved
None.
notice received.
No, Lordship, before it, I think.
The 23/5/25. No, just have a look, Mahanta. How will it get? In the meantime, you call the next matter to Rakhi Twedia, next page to Lilwa.
36.
First time.
Yes,
First time.
Steps has been taken today.
Huh?
Steps has been taken today, Lordship. In the earlier occasion, step has.
Okay. Mr. H. Das.
D. Borua.
D. Barua, learned counsel for the applicant submits that steps as directed earlier has been taken today. In view of the above submission, relist after 3 weeks on a date to be fixed by the registry. Let the registry verify and place up-to-date status as regards service by the next date of listing.
37.
Sure, Bhargav Vahi. Oh, wait, was not one. 1 second, Mr. Sinha. Yes, Mr. Mohanta. Come. Mr. Sinha, just sit for a second. Because there's going to be a change of the stenographer. So he already has the half of the order. Yes.
Lordship, read the whole paragraph, Lordship. Lordship, kindly.
Where?
The order dated, Lordship. Last line probably wrongly written, Lordship. But before that paragraph is duly accepted as if.
Then don't say all this. Naam to read or Koba as prayed for by Mr. A. Fukan on behalf of the Learned Standing Council Elementary Education Department, relist the matter after
My lord, 2 weeks.
2 weeks on a date to be fixed by the registry to enable the department place the records
Lordship allows the date, Lordship.
as directed earlier by this court by order dated 18/11/2024. Yes. Next. Yes, Mr. Sinha?
May it please, your lordship. Your lordship, this is a missed case. It has been filed in a disposed of cases. The issue is like this.
Disposed of contempt case?
Yes, your lordship. May I just place the facts before your lordship?
For what have you filed? For in restoration?
No, what I'm trying to, yes, your lordship, restoration. We are the petitioners in the writ
You
petition.
want the contempt case to be restored?
Restored, no, what happened, your lordship? We have filed a writ petition. That writ petitions, our names were there. Unfortunately, we could not, our names were not there in the contempt petition. Thereafter, we filed an IA for impleading ourselves in the contempt application. Now, the contempt application was disposed of. However, the IA, which was filed by us for impleading our names, was also disposed of, but our names were not reflected. That's the only issue, your lordship.
Now, what is to be done?
So I have filed a missed case saying that our name should be included in that contempt applications.
Whose names?
This applicant's name, your lordship.
Who has been impleaded?
No, they were not impleaded, your lordship. They filed an impleadment application.
That was pending.
That was pending and that was also disposed of with the.
Where is that order?
I'll just take your lordship to that order. That is at page 64, your lordship, of my missed case. That starts at page 59.
It item 37 why? Kamal AC today. Huh? 64, that page is not there, Mr. Sinha.
Missed case, your lordship. It's there, your lordship.
These are all running pages.
The missed case of 2025.
So, file listen.
Missed case to us.
Yes.
So the page starts at 59. If your lordships kindly look at it.
64. In view of the order today, the interlocutory order stands disposed. It says stands disposed. It doesn't say allowed.
No, yes, your lordship, it was.
Mr. Sinha, it doesn't say allowed. Impleadment has to be allowed. Where is the order allowing the impleadment?
That's what our case is, that your lordship, the impleadment application was disposed of along with the contempt application.
But you see, disposal doesn't mean allowance of the prayer.
Exactly, your
Correct, Mr. Sinha?
Yes, your lordship.
Now, the order of the IA, it indicates the interlocutory application also stands disposed of.
Yes, sir.
Where is the main case? Where is that order?
No, this
Where is the main case order?
main case means the contempt application.
Yes.
Yes, your lordship. That order is at page 50. It starts at 53, your lordship. The operative portion.
57.
Operative portion.
57.
Yes, your lordship.
Now it doesn't produce copy of the order passed by on behalf of so and so agrees with the submission. It's complied. It stands closed. Yes. What is there for impleading and all?
Your lordship, the
Sorry, Mr. Sinha.
May I just pray, your
You
lordship?
see, if there was an impleadment application pending, you should have pressed for that, got yourself impleaded, the cost title had to be amended. Thereafter, everything would have been fall on its part. Sadly, nothing has been done. Now, the contempt is already closed. Contempt is already closed. And contempt is between the contemner and the court. The court has found that yes, the order of the court has been complied and closed the contempt. That's all. Sorry. Mr. Sinha, I've understood what you want. According to you, on the date when the contempt petition was closed, there was an impleading application pending as well. While closing the contempt case, an order was also passed disposing of the impleading application. Correct? Correct. Now, whatever has been done is done. The main contempt case has been closed. The moment that case gets closed, any application pending also automatically gets infractions and disposed of. That has been done, and it's a contempt matter. It is not some writ petition. No prejudice is going to be caused to anyone. And I'm not on prejudice also. It's a procedural thing, you see. This cannot be done. If there is any grievance, you see what else remedy you can go for. But otherwise, I don't see.
No,
I'm sorry.
The only issue is that, your lordship, I leave it to your lordship. The only thing was that we are the original petitioners. Unfortunately, the names are missed out. Therefore, we want our names to be there.
If the order has been complied, your names need not be there in the contempt case. You are already there in the writ petition. Yes, please take down. Heard Mr. R. Sinha, learned counsel appearing for the applicant. Stop. by way of this interlocutory application,
Miscase, Your
comma,
Lordship.
huh?
It's a miscase, Your Lordship.
It's an interlocutory application. It has been registered as a missed case, Mr. Sinha.
Yes, Your Lordship.
Your own application says interlocutory application C.
It was registered as miscase number 47
Yes.
of 2027.
Okay, say miscellaneous application. By way of a miscellaneous application, comma, the petitioner is seeking restoration of the interlocutory application C number 1386/2025 in contempt case C number 451 of 2020. Stop. The case of the applicant is that the applicants were few of the arrayed petitioner in the original writ petition, I
7469 of 2008.
WPC 7649 of 2018. However, while the contempt petition, contempt case C number 451 of 2020 was filed, they have been inadvertently left out from the arraignment of parties in the contempt case. It is the specific case of the applicant that though the contempt case was finally closed on 5/9/2025 by this court, however, instead of allowing the impleadment as sought for in the said interlocutory application, comma, the interlocutory application seeking implement was directed by order dated 5/9/25 along with the contempt case
451.
as disposed of. Mr. R. Sinha, Learned Counsel, so and so says, submits that since the applicants were arrayed petitioners in the original writ petition, the contempt court ought to have allowed the impleadment application prior to closing the contempt case, and since the same has not been done, he is seeking restoration of the impleadment application. Stop. Having heard the Learned Counsel and having perused the material placed before this court, I am of the considered view that a contempt case is between the contemner and the court and the contemner. Stop. It is further apparent reading of the order dated 5/9/2025 passed in the so and so contempt case, which reads as hereunder, quote unquote, comma, that upon the order of this court being complied, the contempt case was closed by this court. It is thus evident that since this court has recorded compliance of the court's alleged non-compliance of this court's order being comma, having been complied, the contempt case was closed. It is further apparent that upon closing of the contempt case, automatically pending interlocutory applications have also been disposed of. There is nothing, hence the present application is bereft of any merit whatsoever, rejected. Yes.
Item 38.
Wait, please, Lordship.
Disposed of.
Steps has been taken, Lordship.
Yes.
11/9, Lordship.
When did you take?
11/9/2025, Lordship.
Though office note dated 24/10/25 indicates that No, Heki Nokoba. Mr. Your name?
US Bora.
US Bora, learned counsel for the petitioner submits that steps in respect of the respondents as directed earlier by this court has been taken on
11/9/2020.
11/9/2025. Released after 3 weeks with a service report, thereof.
Most of the Lordship.
Supplementary is item number 43.
Yes, Mr. Sharma?
May it please, my lord. Pursuant to the order passed by this honorable court, my lord, I had taken steps upon the respondent number 5, but address is not to be found, my lord.
Addresses?
Not found, my lord.
Not found.
Not found. My lord, may I get the liberty from this honorable court to take dusty service upon me?
Yes, let him take.
Nothing in respondent number 5. Address is not correct. Nothing that the DIG rents.
You have the correct address.
Yes, Lordship, DIG.
You give him the correct address.
Yes.
He'll take it.
My lord, pursuant to what my learned friend has just said. Oh, Buddhist. My lord.
Yes.
Yes, my lord. This is a communication by the previous government council, if I may hand over.
No, what does it say,
He's
Mr. Sharma?
serving as the DIG of Prisons Range, Jorhat, Assam. I have taken steps in that address. only.
Anyway, today you want to take fresh, you want alternative mode of dusty.
Dusty.
All right. As prayed for by Mr. P. Sharma, na?
PR sir.
P.R. Sharma, learned counsel appearing for the petitioner, released after 3 weeks on a date to be fixed by the registry, enabling the petitioner to take dusty service as well upon the respondent number 5. And file affidavit of service thereof. Yes, counsels do this communication outside the court. You are hampering the judicial administration process.
Correct.
Yes.
Yes, Basa.
Deeply applied.
44.
My lord, I have prepared the written note, my lord.
Yes.
Along with the judgments.
It ki dila 40? 44 orders.
My lord.
44, Mr. Sharma, this is
Part third.
in the order column.
In fact, my lord, because the IA for stay vacating was listed initially, my lord, so it was listed in the orders column. But on the day when the matter was listed, your lordship had decided to take up the entire writ petition.
Where is the main writ? The order asil tatsa.
Yes, yes.
Hmm? As prayed for with concern, release the matter on so and so. Mr. Sharma, the air condition is disturbing you.
Weather has changed.
I know, I know.
Something changed.
No, that is why. It will be can I order to decide it over so we can release the this order is not complete. We type question. What is this?
Lordship has probably taken up the order dated 3rd of September, my lord. So there was a small placeholders blank there.
Yes.
That was the day when the matter was taken up in detail, my lord. Your lordship had directed the councils to furnish
The written note.
arguments. So we have done-
That I've seen, but for some reason there's been some error.
on that order, my lord,
Yeah.
3rd of September, my lord, that
Anyway, today you are placing what, Mr. Fukan?
My lord.
Written
Yes.
note. And
Yes.
yeah, what about you, Sharma?
I've done that, my lord. I've furnished it, my lord. I've submitted it on.
I'm
the-
sorry, I've just lost.
No, that's.
It's just that I'm not being able to connect to the case immediately.
Yes, my lord.
After so many days, the matter has come. So what does it take over notes? Should do what does it? Mr. Sharma, just have a look.
Yes, my lord.
Did your file kini? Aru Mr. Fukane ki dise sir?
Written submission, written note.
You've got a copy?
Yes, my lord. I had submitted the written note on 11th of September, my lord.
All right, let me
Yes.
go through
Yes,
this.
yes, my lord.
You please find out
Yes.
your note that you have submitted in the
Yes.
meantime. Heard Mr. M. Sharma, learned counsel appearing for the petitioner. Also heard Mr. P.J. Fukan, learned counsel appearing for the Guwahati University. Stop. In terms of the earlier orders passed by this court, Mr. Fukan submits the written submissions as submits the written submission. Relist on such and such date for further hearing. Next Thursday?
Yes, my lord.
Huh?
Yes, my lord.
Next Thursday.
Next Thursday, 6th.
at 2 p.m.
At 2 p.m. my lord.
At 2 p.m. Okay.
In the meantime, I'll find out the acknowledgement. I'll do that.
Next Thursday to key date hobo? 6. 6 can't be so Tuesday to 11th at 2, huh? Is it okay?
Can it be on 13th?
Mr. Sharma, 13th?
My lord.
If there is any difficulty, you let the courtmaster know before I sign.
My lord, we have this.
Where?
Can it be on 12?
Just tell him, ask Mr. Sharma to agree and then give the date to the courtmaster.
Anything. अपने देने की थी.
একটু একেলগে থৈ দিব লাগে দেই এতিয়া এইটো ভিতৰত দি দিব নহলে এইটো কাৰণ এইটো হেৰি কাৰণে থোৱা হৈছে তো এনেকে কৰি দিব এইটো পিটিশ্যন next Tuesday
Next.
No problem. We'll make an attempt on 4th. 4th?
Hello.
4th. Yes.
For hearing item number 40.
May His Lordship, my lord, here the petition has engaged new counsel, KK Singh from Delhi. He is trying to appear before your lordship today, but due to some technical error, he couldn't appear. I pray short time. Simply, my lord, I also another pray is that there was an instruction by the court that like to produce the record of the disciplinary proceedings. And the same has been received by the learner CGG. I pray that like a scan copy may be.
How can they give you the scan copy? You are Wapangla.
My lord.
Huh, Miss Wapangla? How can the scan copy of the records be
I was
given to you?
insisted a lot. That's the reason I have to.
No, Mr. Gogoi, affidavit's been filed.
Everything is there.
Affidavits have been filed.
Yes, my lord.
Now, whatever
Just for
they have, whatever they have submitted in the affidavit, this court has to see whether it is borne by the records or not.
My lord, just for the section of the client, I'm just
No. How can you make that submission, Miss Wapangla? But Mr. Gogoi, I think she can have a look at the records in your presence.
You can glance at any moment.
Yes. If you want, Mr. Gogoi, you did not, in fact, inform the court and get this permission. Mr. Gogoi is a very fair and accommodating counsel.
My lord, yes.
You can just request him and he shall have a look at the records.
Yes, I can very same message to petitioner, but however,
You inform the petitioner the protocols of the
Yes, my
court. What is not entitled cannot be given.
My lord.
These are official
My lord,
documents.
I understand. Yes.
After 18 lawsuit.
As prayed for by MS Wapangla, na?
My lord.
Learned counsel appearing for the petitioner, relist after
After 18,
2 weeks, my lord.
after 2 weeks on a date to be fixed by the registry to enable the newly engaged counsel to appear in the matter. Who happens to be out of who happens to be not a regular practicing lawyer or counsel of this court.
In fact, yes, file is bakadam myself. Obliged.
K Gogoi নামটো দি দিবা হৈ গ'ল